I muted myself. My bad. You guys have to tell me if the fan is too loud. Hopefully you can't see it. But like I said the other day, I think it was yesterday actually. Shit, it's only been a day. I didn't want to go over this bar charges against David Gingras, the attorney for Laura Owens, until we had his response. I don't know. I just felt like I might as well at least wait until you see his side of the story. Some of his response as a non-lawyer, I saw it and I was like, is this something that you really want to put into this document? And I guess we can talk about that. Obviously understand that I'm not an attorney. So there's going to be some stuff that I'm just kind of like, I don't know if this is appropriate, but maybe a lawyer would say a different thing. Hang on one second here. Fake Laura Owens, thank you for the $5. When my attorney needs an attorney, maybe I need to get a new attorney. That sounds expensive. Well, then again, she did just get I don't know if she's paying for the new criminal attorney. Let's put it that way. Because I think, it's possible that their office does some pro bono or something. But thank you, fake Laura Owens. I haven't seen you in a minute. Then again, I took like almost all of last month off from YouTube stuff. I was just busy with real job and sleeping. So, and studying and being sick and just all kinds of stuff. So, I was briefly muted. That's true. Sorry, some people can't hear me. It's because I had the audio muted for a second. So we'll go over this his response to the bar charges. So remember the document that the bar's charging document or whatever you call it. Okay, their complaint was 52 pages in and of itself. So his response is 69 pages, but most of that is like what the bar already put in there. So it's not like huge. You know what I mean? Like the document itself in comparison to the original is not like huge. But there's some stuff in there that is like, I don't know if you're supposed to like make arguments in your answers to these kinds of complaints. I don't know. That's just me. Because and given my limited experience, like I've only seen a couple of cases like this where I've looked at the answers and I just don't usually see these kinds of arguments being made in the answer documents. So, yeah, but first I wanted to address this interesting tidbit about Judge Mata on his blog. I know he's been blogging a lot lately. I haven't been reading all of them, but I decided if it's related to his bar case, I would like to keep up with his version of events just to like get both sides of the story in there. And so I will pay attention to it provided it is related to his bar case. If he starts talking about me being a worm or a sex tape with Clayton because he has made some interesting comments about me and a sex tape previously, if he starts making comments like that, then that's not something that I need to read. And therefore I don't mind not having his side of the story. That's his fault. Right. So as long as he keeps it, related to his case and his professional performance, fine. But if he does like videos and stuff like that, I'm not going to be able to watch that. It's just not great for me. Somebody told me the other day he had mentioned me in one, and I was like, just send me the clip. I'm not going to watch all that. And unfortunately, I can't sit there and listen to all of his arguments because I'm like, I don't know if this is going to be a healthy thing for me to listen to because I don't know what he's going to say. You know what I mean? I don't know if he's going to start talking about Omar or Rachel or whoever, and I'm just like, I don't really want to listen to that. So, yeah. Lauren's hair is very cute. Listen, my hair has an interesting relationship to my head right now. So I keep telling people it's going to be awkward for a while it grows out. I can't do anything about it though. So, what are you doing on time? I'm not on time, right? I was like 7 minutes late or something. Sorry to disappoint. Fake Laura Owens, thank you for the $2. Busy with a real job. What's that? Okay. Well, I don't really know how to explain that one to you. It's not fun though. They take some of your income, put it towards street improvements that you didn't ask for and they don't actually make. That's what a real job is. All right, hang on. Pull this tab up. So I did read this one, and I'm not going to show the whole blog. If you really want to read all of this man's ramblings, go look at the blog. And I know that, people will be like, no, don't give him attention. No, if you really want to hear what he has to say, go read his freaking blog, right? But I will look at this one part because he's been talking a lot about Judge Mata. He seems to have a particular fixation on Judge Mata that I feel like is unhealthy. If I were Judge Mata, I would be a little afraid, to be honest. And this is the point I was trying to make the other day. I was saying, like, it would be in his best interest throughout the course of this case to kind of tone down the rhetoric and to back off a little bit so things can run a little more smoothly for him, because people aren't going to want to cooperate with him as long as he's kind of being scary, in their opinion. Like, because from an outsider perspective, maybe he doesn't mean to come across as scary, right? But it does come across kind of scary. And I can say that as someone who has been on the receiving end of some of the sort of vitriol in court case I had nothing to do with. It is a little scary. It's a little frightening. Because there's one thing to like call someone a shit-eating worm on a blog, right? But then there's a whole other thing to like track their movements or location or when they are or aren't at work and post on their blog about it. It's like kind of scary. And then given he has previously, while complaining about Judge Mata in a video, mentioned having a gun in the car outside the courthouse, like, I understand he may not mean to come across as threatening or scary. I understand he may be thinking like, I would never fucking use a gun against someone when they haven't, done anything. I only have it for defense. But it comes across to someone who doesn't know him, who's not inside his head and who can't tell how he feels or how he thinks, right? That it comes across that he is somebody who unreasonably escalates to attacking someone over things that are kind of menial or not that serious. And so that being on the receiving end of that kind of attention for Judge Mata, I'm sure is very scary, especially when he's like going after her father and her sister. Like, it's got to feel kind of crazy. So he says here that my process server just made contact with Mata's JA. She said Mata was not on vacation. She's just refusing to accept service. My guy, his name is Gary, responded, that is not legal. She can't refuse service. Apparently with that, the JA ended the discussion. Now, the problem with this is that David has either misrepresented or not given the whole truth a number of times. And we'll see that in this bar response. There's at least one spot that I'm a little annoyed with. And I understand it's his version of events. I disagreed with them based on the documents. But the problem with this is he has seemed to the layperson, to the audience of his blog here, he has seemed to misrepresent the truth or leave stuff out quite a lot. So you can't just take his word for this. For all I know, the JA or the department said, we're not authorized to accept service on Judge Mata's behalf. We're not authorized to do this via email. That's what could have been said. I don't know. So I can't really pass a judgment on that. I will say that I don't understand personally, like maybe Judge Mata should just have someone accept service on her behalf. And, to be fair, I don't know why she's not doing that. But if I were her, I would feel pretty harassed by this man. So it's a little creepy, the amount of attention he's giving her online, the stuff that he said in his videos. Again, the gun outside the courthouse. It's like there's a small step, it seems, between her upsetting him and him feeling threatened. And then there's a gun, right? So you don't really, if you're Judge Mata, you don't really want to come into contact with this guy. Maybe it's his process server, but maybe he's also waiting for you. You don't know that. So I'm just trying to convey, like, that's how it comes across, even if that's not how it's intended to come across. It comes across very threatening. He says at the bottom here, I will turn blue in the face repeating this. People with nothing to hide nothing. And I can tell you with certainty, people who have nothing to hide will hide if they have someone to hide from, a scary person to hide from. So that doesn't really mean anything to me. Again, I would think that it would be in her best interest at this point just to have like someone, a lawyer or somebody, accept service on her behalf. I'll concede that. But this, what he's doing in his blog and like talking about when she isn't in the court, and like they're saying that they didn't see her, and I'm like, well, apparently it's not common to just see the judges around the hallways in the courthouse, and like what he's doing is kind of scary. So yeah, I would believe that her department, would be like, we need to avoid this guy at all costs because he's kind of scary. So I think that he needs to, like I said, tone down the rhetoric, because even if he is a well-meaning person who's just trying to defend himself, he comes across as aggressive and he comes across as kind of scary, which if you're working with people in your profession and you have a case that you need to defend yourself in, is not going to work. If these were just two people who, like, she started avoiding him and they were no longer going to be friends, maybe he could just go away. You know what I mean? It wouldn't matter if she didn't want to talk to him. But he needs, apparently, per David, he needs her. He needs to question her. He needs information from and about her for his defense. So he needs to do what is less personally gratifying, which is spewing all this onto his blog in the moment, exercise some self-control, stop doing that, wait until he has what he needs, and then he can kind of speak his mind. I know it shouldn't be that way, maybe, in his world, but if he has a way, a path to make this easier for himself, he needs to use it. And he's not doing that. This kind of rant, a lot of women would feel afraid of this. So I'm just offering like some genuine, that's meant to be constructive feedback. I'm not trying to say like he's a terrible person who's going to commit violence. You know what I mean? I'm saying this, from my perspective, and probably from a lot of other people's perspectives, gives the appearance of someone who has an unstable fixation and is threatening. Whether or not that is true, that's how it looks. So, all right. Give me 1 second here. I'm gonna, yep, okay. Hopefully you guys can read that, okay. I'll try to zoom in a little bit more. I was gonna have Bruce in here, but he was, Stu says you get repetitive in the beginning. So I'm okay with that, is the thing. If it bothers you a lot, Stu, my advice, especially because I have the ADD real bad and I'm going to repeat myself some in the beginning, my advice is don't watch live, because then you can skip ahead, you know? I'm sorry, but I can't make everybody happy, and I'm just going to sit here and speak my mind, and how it comes out is how it comes out, I'm going to be honest. Not salt to you. I'm not like saying anything rude. No rudeness going in your direction. I'm just telling you, if I can't meet your expectations, then maybe like don't watch live, because that way you can skip the annoying stuff. You know what I mean? So, all right, guys, give me 1 second. Yeah, I want to pull up some notes on my other monitor. Give me 1 second here. But I do have this other monitor in my face, so we'll see. All right. So let me close out the blog. Okay. So a lot of this stuff where you'll just see admit, and the thing is, these are just like factual statements. So like, respondent, who is David, represented Laura Owens in Maricopa County Superior Court, admit. So you're going to get a lot of statements like that where it's just, you know, there's not really much there. So I'm going to kind of run through the beginning of this, and I'll skip over the admits when there's nothing else to say, just so we can kind of get through it. And this doesn't take 3 hours. You know what I mean? I think Lauren read and discussed a document from the board. So, oh, okay. So I never read over the full bar complaint, but we'll do that now. So, all right. So he represented Laura in court. After being hired by Laura, he became aware, based on his investigation and research, that she had made contradictory statements about her actions and had altered at least one medical record. Okay, he says admit. Despite being aware that Laura had given contradictory versions of events and altered at least one medical record, David failed to withdraw as counsel for Owens, or alternatively failed to diligently investigate and research relevant facts, pursued claims that were without merit, prepared an affidavit for Owens to sign that included false information, failed to take steps to address false statements that Owens made during her deposition and 2 hearings, and presented Owens' false testimony to the court. Okay. So David says he admits to the allegation that he presented testimony from Laura to the court, which he did not know was false, and that he prepared an affidavit for her to sign, which he did not know contained any false information. He denies all the remaining allegations of the paragraph. So he's saying he did not know the testimony from her had like false information, right? Or that he gave her the affidavit to sign with false information. And I don't think that that is really going to work out in his favor. We'll have to see what his arguments are later on. But he's going to have a hard time with that one, because he might say, at the time, he might have said, like, this stuff was before my time, or XYZ was before my time. But apparently, like, he had to do his due diligence as a lawyer when he came onto the case to kind of get up to speed on everything and to pay close attention to everything so that he knew what he was talking about. And the before my time thing was apparently not good enough. I don't know. I remember when he stood up in court and said that. And I just thought, that's some really bad lawyering. But I didn't realize that it was, you know, there was an ethical obligation to to do more than what he did, I guess. And so that is something that's possibly getting him in trouble now. So, one sec. Okay. During the period of representation, respondent failed to comply with the court order, directing him not to disclose outside of counsel for the parties any medical or other documentation disclosed between the parties. So during that hearing that Corey was representing Laura at, and this was at the end of February, like last week of February, I think, around the 21st or the 22nd, Judge Mata said that the parties should not disclose medical records outside of themselves. Things that were disclosed between the parties should not be shared outside of that. So Corey Keith, obviously, and Gregg Woodnick stipulated to that. The judge did put that into her minute entry. So there wasn't like a formal written protective order, which he says means that he could do whatever he wants. Everyone else that I've heard from seems to disagree. So I'm a little confused on that one. Obviously, he has the right to defend himself. I don't really know what he thought he was doing, because Laura was trying to get everything in the court proceedings sealed based on this statement she was making that she thought Clayton was going to like leak her medical records and shit, and like all that was going to get online. And that's what she was afraid of. And then she hires this attorney who comes in here, ignores what the party stipulated to, and then starts leaking her, not even leaking, just like outright posting, her medical records. Apparently, I would say with her permission, unless she wants to correct the record otherwise. Apparently with her permission. So Laura, trying to seal these proceedings from the public, and we know why that is, because she was lying, said that I'm afraid all this stuff is going to get out. And then she has her new attorney just go ahead and publish it on Twitter. On Twitter. And on his blog. Like, Jesus. So yeah, this is something that he absolutely should have known. He absolutely should have known that he wasn't supposed to do that. Looking at he had to review all that. He had to review the file. He had to review what was said in the hearing. He had to review everything that came before him. And he had to have known all that when he shared those medical records online. Like, she doesn't get to just then say, oh, no, it's fine, and then they get to ignore what the judge said, because she asked Judge Mata to do something about this fear that her medical records were going to be leaked online. And so Judge Mata did. And then Laura says, well, I guess it's fine to post this stuff online. Why? Because what Laura really wanted was for all of this stuff to be hidden from the public. She didn't care about that. So, all right. Fake Laura Owens, thank you for the $5. You want repetitive? Oh, no. Try Friday Night Netflix and Tony Robbins with DG over and over. You should have to pay me $5 for reading that, babe. I don't know what... I don't know who runs the fake Laura Owens account, but you should have had to pay me $5 to read that. So thank you. Thank you very much for the imagery. That was truly horrifying. I don't know what to say. Thank you, though. I think. Thanks, I guess. Yeah. All right. During the period of representation, respondent took steps to prevent Michael Maricini, a potentially adverse witness, from appearing and testifying at a hearing held on June 10th. David says he denies and affirmatively alleges the state bar's allegation contains knowingly false misrepresentations of facts. We'll get to that later on. I don't need to dwell on that too much right now. Okay. During the period of representation, respondent made public disparaging remarks on social media about members of the public and Maricopa County Superior Court Judge Julie Mata, who presided over the paternity case filed by Owens. Okay. He responds and says he admits to making certain public statements, which contained lawful, truthful statements and opinions, all of which are protected speech under the First Amendment to the United States Constitution and the Arizona Constitution. So the lawful, truthful statements and opinions, some of it was not opinion. Some of it was stated as fact. They were accusations being made against the judge, and there was information that he did not include in his complaint that directly contradicted what he was saying. And so that's going to be where he has a problem, because that was not a matter of opinion. It was a false accusation. And we're going to have to talk about that later on because it'll spell it out a little bit more. down the complaint. So, all right. During the period of representation, respondent filed and pursued a non-meritorious appeal. He says he admits filing and pursuing an unsuccessful appeal, but denies it was non-meritorious. And I'll be honest, the non-meritorious appeal thing, I don't know how convinced I am that they're going to, get anything from that charge. I don't know. We'll see about that. Like, maybe it was a bad, like I said earlier, bad lawyering. Maybe it was, like he said here, unsuccessful. I don't know. I don't know if they can get him on, like, intentionally pursuing a non-meritorious appeal. I don't know if they could do that. We'll find out, though. So, all right. He's licensed to practice in Arizona. That's fine. On August 1st, Laura Owens filed pro se a petition for court order for paternity and legal decision-making, parenting time, blah, 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 against Clayton Echard. The petition for paternity alleged Owens became pregnant by Echard. It's on September 14th, prior to respondent David's involvement in the paternity case, Owens filed pro se an expedited motion to seal court record, asking the court to seal the entire record in the paternity case. Right. Owens attached to that expedited motion copies of several email messages from Echard to Owens in which he sought evidence that she was pregnant. Okay. Echard asserted in email messages that Owens was not pregnant by him, had never undergone an ultrasound, had offered illogical excuses to delay testing, and had provided him with a sonogram that had been created from an image on the internet. So these kinds of things, like, he has to review the file when he takes over the case. It doesn't matter that he wasn't her attorney back in September. He has to review the file, look at this stuff, and do his due diligence to, like, make sure that Laura is telling the truth, that they're not presenting false information to the court. And it doesn't appear that he did a very good job of that. So that's just my opinion, but all right. Among the email messages attached to the expedited motion was a July 25th email from Echard to Owens, which reflected that Echard believed Owens had provided him with a fake sonogram. Okay. The motion indicated that Owens had failed to provide Echard with evidence that she was pregnant, right? Owens' September 4th motion and other documents in the court record, including Echard's email messages to Owens, placed David on notice that he needed to be diligent in A, ensuring that Owens was truthful about her health, alleged pregnancy, medical records and events, and B, determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Echard was the father. Okay. David responds to this by saying he denies that a pleading filed by a pro se litigant more than 7 months before respondent met that litigant in a case in which David was not involved, somehow placed David on notice that he needed to be diligent beyond the normal duty of diligence owed by every lawyer in every case. So that's the thing right here, though. The normal duty of diligence owed by every lawyer in every case. And he doesn't seem to have met that standard because he did all this before my time crap when really it was his job to familiarize himself with everything that happened in that case before he took her on as a client, before they went to the hearing. You can't just ignore that stuff and then present false evidence and be like, well, I didn't know, because you did know, or you should have known. And the problem here is not that they're saying he absolutely, if he did, present false information with, like, not knowing that it was false, but he didn't do his job and his due diligence in trying to determine whether or not it was true, that is a problem. So that's kind of what they're getting at here in a lot of this. So it's like, are you lying or are you kind of dumb is the question. And I've said that a bunch of times before, and I'm not even saying that to be rude. I'm saying that's how it comes across. If you're like, no, I don't think that I needed to know this stuff, you come across as a bad lawyer. You come across as a dumb lawyer. Like, so, well, maybe it is really like that then. It's like, were you doing a bad job and a negligent job as a professional, or were you actually doing something nefarious? And you have to kind of admit to one or the other there, because he got it very, very wrong. There's no coming out of this in which he looks like a good, competent lawyer. Maybe he wasn't committing any crimes. Maybe he wasn't, in the best case scenario, he wasn't violating any ethical rules, but he's not. Like, he's coming out of here not looking like a good lawyer at all. It's not good. It's not good. 1 sec. Respondent had a duty to diligently investigate and research everything that Owens told him or provided to him. And his response says, this allegation contains a legal conclusion for which no response is required. Okay, and you'll see this a lot. This is kind of like a standard response statement. But in the context of this fact, oh man, okay. To the extent a response is required, respondent asserts the state bar's allegation materially misrepresents the law in multiple respects. So he underlines this part here. It says the prohibition against offering false evidence only applies if the lawyer knows that the evidence is false. A lawyer's reasonable belief that the evidence is false does not preclude its presentation to the trier of fact. A lawyer's knowledge that the evidence is false, however, can be inferred from the circumstances. And that's the problem. He's like bolding and underlining all this stuff before, but he's ignoring this part right here. A lawyer's knowledge that the evidence is false can be inferred from the circumstances. If a lawyer reasonably believes that evidence has been materially altered or generated with the intent to deceive the court, the lawyer has an obligation to conduct a reasonable inquiry before submitting the evidence to the court. Okay, I'm not sure how that's helping his case, but the scope of the inquiry will vary according to the circumstances of each case, but factors to consider may include the probative value of the evidence, which in this case, he says it's not material and it's not important, but it is. The value or importance of the case or issue, the source of the evidence, and what, if any, accessible, reliable, and affordable tools or methods are available to assess the evidence's authenticity or integrity. And this one, again, right here, this part that he has not highlighted is going to be a problem for him. If after inquiry, the lawyer still does not know that the evidence has been materially altered or generated with the intent to deceive, the lawyer retains discretion to submit the evidence to the court. Okay. The problem is, again, like what he didn't include here, because that right there is going to hurt his case. But respondent affirmatively alleges that comment 8 to ER 3.3 is an accurate statement of the law, and the lawyer is obligated to conduct a reasonable inquiry when he believes a client may have altered evidence or offered false testimony. He affirmatively alleges he complied with his duty in all respect at all times. He further notes, as explained elsewhere, that sonograms are, God, here we go, as a matter of law, not relevant, nor are they material to the issue of paternity. But he knew that whether or not Laura was actually pregnant was an issue in this case that he took. He knew that she was being accused of lying. He knew that she was being accused of not being pregnant at all. So sonograms are by Arizona statute not admissible or even relevant to the issue of paternity. Okay, but he was seeking, fees or sanctions at some point. I know they withdrew the 26 motion, but he was seeking fees and sanctions on the basis that she brought forth fraudulent claims to the court and that she was not actually pregnant, much less by him. So it was relevant to the issues in the case. He's treating this case as if she was definitely pregnant and he was just there to help determine whether or not Clayton was the father, when the real issue was she was never pregnant. She brought forth false claims to the court. My God. 1 second. Did we get a confirmation on whether Laura's accomplice? No, not to my knowledge. No, I don't think so. And I mean, correct me if I'm wrong. I don't think so, though. I did take like a long break from all this. So, all right. So he tries to say that sonograms are not relevant to the issue of paternity. Sonograms by Arizona statute not admissible or even relevant to the issue of paternity, but there were more issues being raised in the case of that. So, God. Hold on. Accordingly, exactly as a comment 8 to 3.3 states, when he learned of the possibility that Miss Owens might have altered or even completely fabricated one or more sonograms, respondent took every reasonable step to investigate that issue, while also keeping in mind that the probative value of the evidence was basically zero, because sonograms cannot be used to prove or disprove paternity, and thus the value or importance of that evidence was minimal. No. No, you cannot deny that the sonogram evidence and her altering or faking sonograms was relevant to that case. That's ridiculous. Oh, hold on. Sorry. So I guess Jim Lee, the bar guy, just filed a motion for judgment on the pleadings. Somebody sent me a text, and David wrote a new blog. I'm not gonna read David's blog here. I'm gonna, go ahead and read the rest of this. But one sec. Please don't do a video explainer. Okay, so what motion for judgment on the pleadings, right? They're saying, like, even if, you know what, let's not even fuck with that right now. Let's not get into my ADD brain, but that's hilarious. We'll deal with that later. All right, Jen can fill you in the chat on what's going on there, but okay. Anyways. He failed to diligently investigate and or research Owens' allegations to determine whether her statements to him, opposing counsel, and the court were truthful, or that the sonogram provided to him and used during a court hearing on June 10th was an image created by an ultrasound performed on Owens. He says, again, this allegation is based on a knowingly material misstatement of the law. Having said that, respondent denies this allegation. And you'll see throughout this document, sometimes he scream denies things. Sometimes he scream denies them in all caps. And sometimes he just denies them. And I'm just like, well, is there a difference? It's like he's texting. He acts like he's texting his buddies about something inconvenient. Okay. On January 3rd, Echard's counsel filed a motion for sanctions pursuant to 26, in which he requested that Owens be sanctioned for filing the petition and later documents for an improper purpose, right? And without medical evidence to support her claim that she was pregnant. So this is why this stuff was important. The sonogram was important because this stuff was being raised, and the court was able to sanction her. Under their own authority and other rules other than Rule 26. But he just harped on this Rule 26 thing again and again and again as if it was the only thing that ever mattered. So yeah, the sonogram did matter. Admit and affirmatively allege that the motion for sanctions was filed in direct violation of the rules. Nobody gives a fuck. Okay? Nobody gives a fuck. This is your answer to the bar's complaint against you. You're not in the family court of law arguing this case again. Stop. Jesus. Echard's January 3rd motion for sanctions, pursuant to Rule 26, placed respondent on notice that Echard had claimed that Owens was not pregnant, was created a duty on David's part to ensure that his investigation and research thoroughly addressed everything that Owens told him or provided to him. And then David says, deny, scream caps. David further affirmatively alleges that he did not represent Miss Owens on January 3rd, 2024, when the motion for sanctions was filed, and did not know about the motion until 3 months later when he was retained on March 25th. Oh boy. Okay. This doesn't matter, by the way, because he's supposed to review the file, like I said, but let's keep going here. On February 21st, Judge Mata issued a minute entry order scheduling a hearing in the paternity case on June 10th to address the issue of sanctions and attorney's fees. Okay, got it. On March 11th, Clayton's counsel filed a motion to compel. Based on the motion to compel, respondent David was once again placed on notice that he needed to be diligent in ensuring that Owens was truthful about her health, alleged pregnancy, medical records and events, and be determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Echard was a father. I'm sorry. This is the most insane rant. This is not how you're supposed to answer one of these complaints. But by all means, go off. Okay, this is going to be a long one, so let's buckle in for that. Don't worry, we'll start skimming over stuff when it gets later in the document, but he filed a motion to continue the DUI. Yeah, that's true. And I know he's gotten, continuances or delays before, so I was trying not to burp. But. In his new blog, Gingras said that Jim Lee filed a motion for judgment on the pleadings. He says it's a way of ending a case early. It means Jim is asking the PDJ to end this case immediately. Yeah, so they're trying to say that even if what David says, I guess what he wrote in this response is not enough, even if the facts, what David says are true, that David's arguments fail based on a matter of law, is my understanding of that. And if somebody can correct me if I'm wrong, But my understanding, based on what I know from the federal cases I've been following, is that a judgment on the pleadings is asking the judge to, even if the facts, if you take them at his word as he laid them out, that they're saying that the case should basically be judged in their favor based on law. So it's, I don't know how successful that's going to be, but I'm not sure that what he's representing on his blog is factually correct. I think there might be some emotion behind it, but I haven't read it yet, so we'll see about that. Yeah. Okay. No, he's doing a great job. Carry on. Okay. All right. Anyways, sort of like sort of a summary judgment, but not exactly the same as a summary judgment motion. It's like something that would wrap up the case though before it ever had to go to a hearing. Yes. So, all right. Anyways, let's go back to what this is about. So the March 11th motion to compel, he once again was placed on notice that he needed to be diligent in ensuring that Owens was truthful about her health, alleged pregnancy, medical records and events, and determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Echard was the father. Here's why. Okay, so I read this yesterday, this motion to compel. I went back over it yesterday. And they were saying that the judge in the February 21st hearing compelled Laura to comply with Rule 49 disclosures. She had not done that. She had avoided it for 7.5 to 8 months. And they had to compel her to comply, to sign these medical releases. I remember the judge made her sign the medical releases in front of her because Laura was dodging. And then she also had to be compelled to attend a deposition because she skipped her deposition. So on March 1st, over a week after the February 21st hearing, where she was ordered to comply with disclosures, she then presented for the first time certain material facts and, saying that she miscarried on a certain date, that she got a sonogram in a certain place on a certain date, that kind of thing, which then there were 3 or 4 items. And I'm not being precise here, so don't quote me on this, but you're getting the gist of the picture here. She disclosed this information for the very first time on March 1st in her deposition after she was, basically forced by the judge to comply with disclosure on February 21st. So they had to file a motion to compel after that deposition to ask the judge to basically force her to comply with records requests for these new issues that were brought up in the deposition that were not known and could not possibly have been compelled on February 21st because they didn't know about them until March. So that's what this is. And they're saying, based on that motion to compel, David should have known that he needed to be diligent in making sure that Laura wasn't lying, basically, making sure she was telling the truth about her health, the pregnancy, her medical records, so on and so forth. Okay? So here's David's interesting response to that. Oh, hey, what's up, man?
Ladies and gentlemen.
Hey, how's the pool?
Pretty good. We're trying to dial in our reservoir, but that's I digress.
I'm just really glad you're not still afraid of the pool.
As long as I put my floaties on, I can handle the pool,
Alrighty then.
Yeah.
Anyways, so I'm
what
reading
have we
through
learned
this.
Here, Lauren? Give me the scoop.
They're talking about this motion to compel information that first came out during Laura's deposition. And they're basically saying that based on that motion to compel, David should have known that Laura's credibility was in question and he needed to be diligent in determining that her statements, her medical records, what she was saying was correct. And he's denying this for some reason. So he says, as repeatedly explained to senior bar counsel James Lee, is that the very same one that he said had cognitive issues?
What? He puts deny in all caps and then he starts underlining things?
Sometimes he just denies stuff and then sometimes he freaks out and says, deny,
I think he's a little worked up. Oh, later he's got the bold underline. That's a twofer.
Am I glitching? Somebody says I might be glitching. Hang on. So you
You
can see
seem
me
all
even though
right.
my comment ghosts as soon as I send it. How weird. It's everywhere in a live chat. Must be a good old glitch. I don't know, man. I can see comments if that helps.
I had to reboot my phone one day because only about half of my comments in a live chat were going through. So
Yeah.
I don't know if it's a YouTube thing.
Well, there were problems with that lately. If you guys are in live chat, like comments were just disappearing. That was a couple weeks ago though, so maybe it's just happening again. I don't know.
Mm-hmm.
Hey Rob, what's up?
All right.
All right. So here's his response to that. He says, deny. As he has repeatedly explained to senior bar counsel James Lee, he again affirmatively alleges that he did not represent Miss Owens on March 1st when the motion to compel was filed. So
11.
This doesn't matter. He came on in late March, but this doesn't matter. He still has to do his due diligence in reviewing this file and reviewing everything that was said and everything that was alleged. He still has to deal with that. And he even filed a motion to try to get extra time to respond to the motion to compel, which was denied, by the way. And so he knew about the motion to compel. He read it, and so he knew what was being alleged, and he had a duty to pay attention to this kind of stuff.
Yeah. If he reviewed the motion to compel, why does it matter that he didn't represent Laura when the motion to compel was filed?
It doesn't. He's still doing this kind of before my time argument when the truth is, like, he needed to know all of this stuff. When he took on the case, it was his job to study this stuff, to understand what was going on, and to know what he needed to investigate. So, yeah. Apparently the latest blog is just more about Mata conspiracy theory. I don't know if you saw that, Bruce, before you hopped on. The bar asked, I guess, for judgment on the pleadings on this, so we'll see. I haven't read it yet. I'm not going to do it on this stream.
Oh, there's even another blog?
Yeah.
This guy is... Oh my
second one today, 2.5 today, because he did a long edit to his other blog today.
This guy's blogging overtime.
Oh yeah. Well, he doesn't have anything else to do, I guess, apparently. But like, maybe getting his roof fixed. Might be bored, just sitting there. Might as well blog, you know. All right. David further affirmatively alleges that after he was retained on March 25th, he reviewed the motion to compel and learned that the attorney who filed it, Echard's counsel Gregg Woodnick, lied to the court in that pleading. Among other things, Mr. Echard made multiple knowingly false representations of material fact to the court, including 1. Mr. Woodnick falsely stated in the motion at Petitioner Laura Owens' Rule 57 deposition, Petitioner testified she miscarried 2 hand-sized fetuses sometime in September, October. So,
okay.
In truth, as reflected in the deposition transcript, Mr. Woodnick simply lied to the court about this fact. And this is not a lie. It's splitting hairs over wording. So he said hand-sized fetuses. What she actually said was like slightly smaller than hand-sized fetuses. And so he's saying that Gregg Woodnick lied to the court because he said hand-sized fetuses, which is interesting because he's trying to harp to death in this document about how it's immaterial and unimportant that he represented, or like he didn't go into detail or investigate the sonogram that was faked. And he's like, that's not important. But this thing that Gregg Woodnick said about hand-sized sacks, when it was actually smaller than hand-sized sacks, is a lie.
Where's the... So here's the problem. So he's saying Woodnick put this in the filing, and he's got that in number 1 and number 2. Why are there 2 of them?
What are we talking about? Sorry.
Maybe he's talking about 2 different states. The problem is
the
he doesn't say what she did say. Does he say that later, like on the next page?
I don't think so, but I've heard him make that accusation enough. Hang on, let me see. When she miscarried, she took photos of what would have been 19 to 24-week twin fetuses. In truth, Mr. Woodnick lied to the court about this fact. So again,
hold on. What did she say in the deposition?
Unclear.
Why doesn't he have the quote of what was in the deposition so we can check it against the Woodnick text?
I'm really not sure. I mean, I know the answer, but
this is not convincing. You have to take the actual quote from the filing, and put it next to
he's fucking quoting everything else and putting links to YouTube videos. He's got a link to Megan Fox's YouTube video in here, and he couldn't quote this in the deposition. Like, if you're gonna argue, let's argue. Let's do it all the way. Let's not half measure.
What does this have to do with Wait, what is he complaining about here? The bar is complaining that he didn't get all the proper medical records. What did
So
these
yes, so
what
they're
does this
saying
photo of this flesh have to do with getting records?
it doesn't. So they're saying that because of the March 11th motion to compel, which he came onto the case a couple weeks after that, and they hadn't responded to this yet. Because of this March 11th motion to compel, he was notified basically per that motion to compel. He should have read that. He should have known that he needed to diligently investigate Laura Owens' claims and made sure
Yeah.
she was truthful about her, health claims, her alleged pregnancy, her medical
Yeah.
records, because she was lying about it and it was coming up for the first time in the deposition on March 1st.
Yeah.
And so he's
Oh.
responding to this basically by saying no, because Gregg Woodnick lied about hand-sized sacks.
Well, we don't know how he lied because he's not explaining it very well here.
Well, he has previously, and not here in this document, he's not, so that's not going to do him any favors, but he has previously said that it was a lie because what Laura actually said was like smaller than my hand, not hand. She used the hand as a reference point, which is an easy mistake to make. It's not a lie. It's like that is what I would actually call a misstatement, is like saying hand-sized instead of smaller than my hand. You know what I mean? Like,
So
that's
here's the thing. Here's the thing, Lauren. If I say there's an object on my desk and it's smaller than my hand, okay?
I don't need to see your penis, Bruce.
Well, let's assume it's some other object on my desk that's smaller than my hand.
Go ahead.
Okay. Now I'm off the rails. Let's say there's an object on my desk that's smaller than my hand. That object still could be hand-sized because hand-sized scales from, you could have a newborn baby with a hand this big, right? Or you could have Shaquille O'Neal with a hand this big or something, right? So hand size covers a lot of ground, right?
Maybe, maybe it was the size of my hand. I got tiny ass hands.
If
Maybe
Laura
Gregg
says
Woodnick doesn't. I don't know.
there were two pieces of flesh that were smaller than my hand, those pieces of flesh could still be hand size. They would just be someone else's hand size. So it's technically not incorrect.
Bruce keeps that on his desk. That's what I'm
trying to keep it. I'm trying to keep it logical here. I'm trying to keep it logical. So the hand size thing to me was never like, it was never really substantive to anything.
That is what we would actually call, you would actually call that immaterial.
It's not quantitative, it's qualitative. And hand size goes from very, very tiny, like a little newborn, all the way up to Shaquille O'Neal. That's a huge range.
Doesn't matter in this case, not in every case. Yeah, no, size doesn't always matter, ladies. I mean,
good.
Come on.
At least
especially when it comes to hand-sized fetuses.
At least in some places, size doesn't matter. I'm relieved.
Well, I would say one of the places where it does matter is Bruce's desk, but we'll get into that some other time.
Oh boy, it's a very big desk.
Shut up.
But the other problem here is if you don't know all this stuff you're talking about, where does he explain the problem in this filing?
Unclear. He kind of rants about things that don't matter. But I guess we'll read it anyways, right?
Yeah, let's keep going. Maybe he'll explain it.
Yeah, maybe not.
He could do it.
Anyways, Mr. Woodnick falsely stated in the motion that she miscarried 2 hand-sized fetuses. He also falsely stated in the motion that she testified when she miscarried, she took photos of what would have been 19 to 24 week twin fetuses. What I'm guessing is that he would say it would have been 19 to 24 week twin fetuses based on the original date that she gave them. This is my total speculation. He would have estimated 19 to 24 weeks based on the dates of pregnancy that she originally gave them, whereas she's operating on this newfound, like, newly creative date of conception and pregnancy timeline that she has created. So I don't know. Maybe that's why. In truth, as reflected in deposition, Woodnick simply lied, whatever. Mr. Woodnick falsely represented to the court that Ms. Owens' petitioner willfully and wantonly failed to disclose information pursuant to Rule 49. That's absolutely true. That's absolutely true. And that she had been evading any compliance with Rule 49 for over 8 months. So he's saying that Woodnick lied about this, but the truth is it was about 8 months. So August 1st, 2023, when she filed the case, she evaded compliance with Rule 49 for over 7 months, almost 8 months. So it was end of February, which is the end of the 7th month, into March 1st, marked month 8. So he's trying to say that like this was a huge lie that he said over 8 months when the truth is it was over 7 months. And that's what he's trying to distract with. Basically say Gregg Woodnick is a dirty little liar. When the truth is like his client lied and he's trying to distract with semantics or like bad math.
Wait, so it should be 7 months instead of 8 months?
Correct. It should say over 7 months, not 8 months. It was exactly 8 months when she first disclosed the information about the new pregnancy timeline she was giving, about the new location of the ultrasound she was giving, and that she altered the ultrasound.
Well, that was... Wait, isn't it way more than 8 months? Because we didn't learn until June 10th itself about this LA Planned Parenthood, right? So that's the end of the measurement, isn't it?
Right. But the motion that he's talking about was filed in March. Is March 11th. So the timeline for the lies, I guess, would be 8 months. It would be from August 1st to March 1st, or from August 1st to February 21st. So at the lowest, the amount of time she spent evading compliance with disclosure was 7.5 to more than that, 7.5 to 8 months.
That's about 8.
Right, exactly.
If you count all those months, that's about 8.
And he said over 8. So again, that is an actual misstatement. Not, I went to Planned Parenthood Mission Viejo. Oh, wait, no, it was actually Los Angeles on the day of trial. That's not a misstatement. Saying over 8 months when it was actually about 8 months, that's a misstatement. And he tries to attack this man and his credibility. Instead of defending himself against the bar's complaint, he tries to attack Gregg Woodnick.
I mean, here's the thing. Here's the thing. If Woodnick makes a filing and he says 7.75 months, or he says 8 months, what if I run 2 universes in parallel and one of them he says 7.5, 7.75, and the other he says 8? Mm-hmm. Do we have different outcomes from those 2 universes? I don't think so.
No.
So who cares?
Well, it's who cares when it comes to stuff that he doesn't think matters, like whether or not an ultrasound was real. But when it's like, what was it, 7.5 or 8 months? It's like the end of the world. So it's just ridiculous. I'm like, this makes you look completely unreasonable in front of your peers, in front of the judges. Yeah. It's like, it's not a good look. So stop attacking other people and start defending yourself. That's the only way you're going to get out of this.
The other problem with this statement is that it says that Ms. Owens fully complied with her duty to disclose all information, but she didn't because she disclosed new information on June 10th. So that statement's incorrect, isn't it?
I mean, technically, yes. I'm looking at things in the timeline of like when this all took place, the March timeline, but technically you're correct, yes.
No. That was part 1. I'm talking about part 2. He makes this whole other sentence here. In truth, Woodnick knew that before the motion to compel was filed, Ms. Owens had fully complied with her duty, but she hadn't because she disclosed new information on June 10th. So this second sentence is wrong.
So you're right. Sorry, I wasn't looking at that. So Corey Keith filed a statement regarding the Rule 49 disclosures on February 23rd. And then on March 1st, she came up with new facts and new information that needed to be disclosed. So she did, in fact, evade her Rule 49 requirements there.
Multiple times then.
Right, yeah. Mm-hmm.
Oh my goodness.
And so he's saying Gregg Woodnick lied, but because he says because Corey Keith filed a Rule 49 disclosure statement on February 23rd, Woodnick was lying that she didn't fully comply. But the thing is, she did not fully comply because on March 1st, over a week after February 23rd, when Corey Keith filed that statement, over a week after that, she disclosed for the first time new facts and new things that would need to be investigated. So he's saying like Woodnick lied, and that's not true. Well, it's a flat out lie. It's not true.
The other problem is, we have the concrete examples of providing new information after this disclosure. And then Corey Keith himself filed a motion of candor later on.
Right.
Which
he
is
tried to
even
him out of, right?
Like you can't even ignore that. Like you might be like, okay, maybe Laura said something goofy on medium.com or something, but Corey Keith literally filed a motion of candor, and we have the June 10th new information that was highly publicized. How you can't ignore these things.
Well, I don't know if you heard, but the sacks were less than hand size, so none of that matters.
Oh boy.
Yeah. All right. Let's not stay in the weeds with this man. Let's move on. David further affirmatively alleges that in addition to making multiple knowingly false representations to the court in the motion to compel, Mr. Woodnick made other knowingly false statements to respondent during the course of their discussions. Not true, but who fucking cares? Even if it is, you're defending your license here. We're not putting Gregg Woodnick on trial. Upon learning that Mr. Woodnick had lied to him, respondent confronted Mr. Woodnick and demanded an explanation as to why Mr. Woodnick had lied and to respondent and to the court. In response, Mr. Woodnick refused to communicate with respondent, resulting in respondent moving the court for an order requiring Mr. Woodnick to speak with him. That's the lunch motion, right? So what actually happened was...
Oh, boy.
Okay, and I went over this yesterday, but what actually happened was Gregg, in talking to David, and David came onto this case on March 25th, and David comes out hot saying, there's stuff to do with his expert report. You're not disclosing what your experts are going to say fully, and I need you to do that. And Woodnick comes back and says, well, we're waiting for compliance with what we asked for in the motion to compel, because our experts cannot fully form their reports and their opinions, and we can't tell you exactly what they're going to say until Laura provides us with this brand new information that she disclosed for the first time on March 1st. And so he says, I'll go to lunch with you. Multiple times he said, I will go to lunch with you because the emails are in exhibits, right? After you guys provide us with this information and we can give it to the experts, because otherwise we can't hash out and, resolve this issue with the lack of, whatever information he wants from the experts until you provide what our experts need in order to give their opinion. So he had to, in order for them to, confer on these issues and come to a resolution, he had to disclose certain medical information from Laura so the experts could look at it. And Woodnick didn't say, no, I won't go to lunch with you. No, I won't talk to you. No, I won't meet with you. He said, we'll do this after our experts have had the chance to look over the information we need you to disclose. And the court has now compelled Laura to disclose. And they were just refusing and just beating around the bush. And then he was like, well, Woodnick won't meet with me. When the truth is, Woodnick said, 1, I'll meet with you after the experts have the information they need. And 2, with a neutral third party present. So I guess that bothered him.
I mean, the thing to me, Lauren, that it's sort of like, okay, let's say you have this misunderstanding happening here, right? Between the two sides of litigation. Gingras sits there and says, I think Woodnick is lying. He's lying. He's a liar. You're a liar. Have lunch with me and explain yourself. This is not like jumping to the conclusion that somebody is lying, AKA they are trying to deceive you on purpose.
Yeah.
Is a strong claim.
Right.
And if somebody, if Woodnick puts 8 instead of 7.5, is he really trying to deceive anyone? Like, we don't know what the root cause is. If Woodnick thinks he still needs information, even though Corey Keith filed whatever he filed, he's not trying to deceive anybody by saying he still needs more information for his medical expert.
Right.
This idea that the minute somebody says something you don't understand or doesn't make sense to you, that they're lying it's a bridge too far. You have to treat other human beings with, some sort of, I don't know, some grace so that you can figure out, did they make a mistake? Are we miscommunicating? Did I read something wrong? Did they write something wrong? Are they actually lying? Like, what's happening here? Did they misspeak? I mean, who knows how many times Dave Neal and I get burying the lead wrong. If you say bury the lead, we say it backwards or something.
Right.
But it's not because we're lying. It's just because we're, goofy dudes on YouTube. And I think someone in chat mentioned it. It's sort of this deflection. Like, he needs to be focusing on the claims that the bar is making against him and providing the evidence that refutes those claims, not just like he's sitting here trying to throw this other guy under the bus, which is like, don't pay attention to me. Look at this guy over here. Or it's sort of like whataboutism. Oh, you think I did something wrong? What about this guy over here? It's not fair. we're not litigating something with Woodnick right now. We're litigating something with him. And he needs to focus on that without all this whataboutism.
Well, this is what I said earlier. It's like he needs to have his lawyer step in and do this. Like he should not have done. He did not have to respond in 2 days. He had a deadline to respond that was much further out than 2 days, and then he like bragged on his blog about I took 2 days to respond, and I'm like, you should have let your lawyer do this because what the fuck he's doing in this motion right now? It's fodder for blog drama. It's not a defense. Like this is bad. This is bad. It makes him look worse. Okay.
Is that what we are, Lauren? We're blog drama?
Apparently. That's kind of what this guy's legal stuff is, apparently. Anyways, let's not dwell too much longer on this. Upon learning that Mr. Woodnick had lied to him, respondent confronted Mr. Woodnick, blah, blah, blah. Mr. Woodnick refused to communicate, aka said he wouldn't go to lunch until after the disclosures were made. Because why the fuck would you go to lunch before then? Respondent affirmatively alleges that Mr. Woodnick's repeated acts of dishonesty and Woodnick's refusal to speak with respondent in violation of the rules of family law procedure and multiple ethical rules caused him to reasonably conclude, that is not reasonable, by the way, that Mr. Woodnick was not a truthful person and that his allegations regarding Miss Owens were false. These unlawful and unethical actions by Mr. Woodnick, which respondent asked the court to stop, but which the court refused to do because it was ridiculous, further caused respondent to reasonably believe that Miss Owens was telling the truth and Mr. Echard was not. So let's not do our due diligence and investigate Laura's claims. It's Gregg Woodnick's a liar, so I don't have to worry about anything else.
Lauren, this thing blows my mind right here because what he's saying here effectively is Woodnick wouldn't go to lunch with me and explain himself.
Right.
Therefore, I believe Laura was pregnant. Those things have no causal connection at all.
No. And that's what I'm saying. Like, his lawyer needed to do this for him.
In the thought experiment, Woodnick could be a liar and a cheater and a troublemaker and a criminal. And Laura could be committing the fake pregnancy fraud and all that at the same time. Both things could be true. One being, his assumption that Woodnick doesn't want to have lunch with him and is therefore like lying to him does not mean his client is correct about her claims. These have to be independently verifiable claims that are totally separate. They have nothing to do with each other. And he's causally connected them in this document in a way that makes no sense at all.
No, it doesn't. It doesn't make any sense to anyone but him and like maybe his 3 friends. I don't know. Like somebody in this man's life needs to stop him and be like, wait, you have a lawyer who's going to help you with your anti-slap motion. Could Randazza not have filed a response for him? Because it would have been the responsible thing to do for him to explain his side of things to Mark. And then Mark, being a pretty decent attorney from what I can understand, I don't follow him religiously, but like I've seen some of his stuff, which I thought some of his stuff is like really snarky and funny with the free speech stuff. But like I think that he's a decent enough lawyer to have been like, David, we should not be putting this in this document. This does not make sense. And he just, I don't know. He responded in 2 days. He responded like it was a blog post and not like it was a legal defense. And it's just bizarre. Okay, so we'll keep going through this. During or about March 2024, Owens hired respondent to represent her regarding the motion for sanctions. Yeah, okay. Filed a notice of appearance on her behalf in the paternity case. Yeah. Upon agreeing to represent her, he had a duty in preparing her defense to the motion for sanctions and represent her at her hearing. Okay. We don't really need to go through that. It kind of says more of the same. He had an obligation to diligently investigate and research both their assertions, carefully review the entire court record, and he, used that before my time excuse even during the hearing. Stood up, and I remember that because he stood up and said, "Oh, that was before my time," and I was like, "Should you be saying that here in the hearing in front of the judge?" And I remember him saying that, and I remember thinking, I guess he can do that. I don't know, but apparently not. Apparently, he had a duty to carefully review the entire record and can't just be like, that was before my time. So yeah, review the file, review the information. So they're basically saying he didn't do that, which he, basically admitted to when he stood up in front of Judge Mata and said, that's before my time, to stuff that was being brought up in court. So, all right. On March 6th, Echard's counsel filed a motion for relief from judgment based on fraud, right? And the motion for relief from judgment stated in part that plaintiff Owens was never pregnant. I think it means 6 months pregnant by defendant Echard, as they did not have penetrative sexual intercourse. Admit. Okay.
I was never 6 pregnant.
No, just with twins, not
this filing is so, man, I want to update my little tag name again now.
Blog drama moose is good. All right. Let's see. The motion for relief from judgment further stated that Owens had admitted during her deposition she had modified the medical records. Okay. Admit the motion contains certain allegations. Yeah. All right. The motion for relief from judgment noted that Owens had provided no verifiable medical evidence to support her alleged twin pregnancy. He admits the motion contains certain allegations. Let's see. I don't think I need to read every single one of these. This one he denies. The motion for relief from judgment again placed respondent on notice that he needed to be diligent in ensuring Owens was truthful about her health, alleged pregnancy, medical records, and events, and B, determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Echard was the father. Those two issues were relevant to the motion for sanctions. And he denies that. I'm not sure how, and I think that's why this is one of the few things that he doesn't have a lot to say about. He's just like, deny. No, I don't think I needed to know all that. No, I don't think I needed to pay attention to all that. Like, okay, buddy.
I don't, oh no. He has no comments.
Right, and that's what kind of like, that kind of baffles me. It's like he has so much to say about how Gregg Woodnick is a liar, but when it's like, you should have, because of this motion, known that you needed to know if she was truthful, if there was any evidence, and that those like issues were relevant to the motion. And he's like, nah.
He's always had this argument that, hey, this is just a paternity case. And once Laura realized she was no longer pregnant, everything about paternity becomes moot.
Right.
So to me, I think that's his mindset. I mean, I'm speculating a little bit, but I think that's kind of his mindset on this, since he didn't provide anything else. Which, you know, the problem with that is there was a response in the paternity case. So they needed to work on a ruling of non-paternity and fees. And of course, non-paternity, if you can't prove you're ever pregnant,
right,
you should receive a ruling of non-paternity, because nobody can be the father if you were never pregnant.
Right.
Well, which means everybody gets a ruling of non-paternity because there was never a pregnancy. Well, unless you can prove it.
Even if it's not about not being pregnant, if they're making repeated allegations that medical records are faked, that these records are not real, that she didn't actually go where she said when she said it, those things are relevant. You have to pay attention to that. You can't just be like, you know what? I don't think that's important to whether or not he's the father.
Yeah, it's a pattern of behavior, right? Which is what Woodnick and Gingras were trying to demonstrate the entire time.
So he tries to say with some of this stuff, notice of appearance and notice pending motion on Owens' behalf. Okay, we're not there yet, but to where I was getting at, but we'll keep going. We don't need to do that. Okay, they had the hearing. During that June 10th hearing, Owens provided false testimony about matters pertaining to her alleged pregnancy. David says he lacks sufficient information upon which to form a belief as to the accuracy of this allegation, and therefore denies. So he denies that Owens provided false testimony about matters pertaining to her alleged pregnancy on June 10th at the hearing. Here's the problem with that. He admits later in this document that he accessed her Planned Parenthood portal a while before the hearing. And so therefore he knows that she did not go to Planned Parenthood Los Angeles and get an ultrasound. Otherwise, they would have had that to present at the trial. So this is pathetic. I mean, honestly, I might have, if he had gone through all this with her and then after the hearing was like, well, I don't know what else to say. I'm not going to blog anymore. I'm not going to talk to people anymore because she made up some shit. And then he just did his best to correct the record. I wouldn't be hanging, shit on the guy right now, but I don't know. Even I'm trying really hard to be like even-handed and consider all angles here, and I'm just like, this is absolutely wrong what this man is doing. And the way he talks about other people being not following the rules, or Gregg Woodnick being a liar, and people doing XYZ, I'm just like, what you're doing right here is clearly very wrong, and you're still pretending. You're still pretending after accessing her Planned Parenthood portal. You're still pretending you didn't know that she lied about the Los Angeles thing.
The response to number 36 is kind of bothersome because at this point,
right,
he should know more about the case and whether or not certain things were correct or not.
Right.
Maybe at the time,
they appealed.
If he wants to argue at the time, he didn't know that something was false.
Right.
I guess that's what he's doing in the 37 response, because in 37, I actually think the bar complaint here is weak because they say respondent failed to correct or clarify Owens' false testimony. So which one and what was he supposed to do about it? And how did he know it was false at the time they were there on June 10th? They don't explain that. So I think this 37 argument is a little weak, but the 36 one is pretty strong.
Okay. Laura claimed there was no Planned Parenthood portal. Can someone point me to that? If you can point me to that. I don't recall that, but there's been a lot that's going on here. So yeah, I don't know.
Did you hit the Google search yet or no?
Whether or not there's
part 2. There's a screenshot of a Google search in this.
Oh no, I know what you're talking about. We haven't gotten there yet. But we'll get there. Don't worry. I'm gonna start.
We're only on page 14.
Oh no, I'll move this a little quicker. Don't worry. Okay,
no,
let's keep going here. On June 18th, she entered a ruling. Okay. Right, we don't need to worry about that. Application for attorney's fees. Yep. Okay, this is not like novel information. And if he's not saying anything substantial, I think we can just kind of go through it because we all know this. Okay, he's shouting here. So, respondent knowingly violated Judge Mata's order by disclosing information and documents related to Owens' medical records in his motion for extension of time to respond in declaration. He says deny. Again, he does not recognize the thing that the parties stipulated to in the February 21st hearing and in the minute entry, which is a valid order by the judge. He does not recognize that as an actual order not to disclose medical information outside of the parties.
I would say, and he doesn't explain anything here, right? It's just all caps deny.
Right, that's what I'm saying. Like when it comes to Judge Mata and some of these people, he's like, deny! He's screaming. And I'm just like, yo, chill out.
But for people watching the video in the chat or in the audience, if you've only watched the February status conference hearing like once when it happened or something, go watch it again, because I think in hindsight, knowing if you're into this case and you're getting deep into this case, go watch the February status conference hearing again. It's on the Schnitzel Ninja channel. And I think it's very interesting to watch it with the perspective of everything we know now. Yeah.
So a lot of these I'm going to skip over because it's about the same type of stuff. But here it says on April 4th, and I read this email yesterday, Gregg Woodnick sent an email message to respondent, which stated in part, I am also not certain why you're publishing court documents and your client's personal medical records contrary to court order. So he knew that he needed to pay attention to that and at least clarify. Laura Owens needs to comply with the order and provide disclosure. He admits that Gregg sent an email, right? And he affirmatively alleges the above statement is not a complete discussion of the subject matter. That doesn't mean anything. That doesn't mean anything. So
certain statements.
The email message from Attorney Woodnick placed respondent on notice that he needed to take some action to seal Owens' medical information and documents. He's like, nah. So he's still going to argue, like, he's still going to try to argue that Judge Mata did not order them not to share medical records outside of the parties, or like to try to like seal things out unless it was disclosed between parties. We shouldn't be sharing that outside of that because that's what Laura asked for. She didn't want this stuff to get out. And he's just like posting on his blog and Twitter and shit. And he's like, no, that wasn't a thing. It's fine.
It's so weird because he acts like he's the only one who understands what the rules really are and that everybody else is wrong. And it's like, look, I don't think it's the case that literally everyone else is wrong.
Right. But at the very least, he should have here after Gregg Woodnick, who he claims is a liar, by the way, brought up, there's a court order. Why are you doing this? He should have at least tried to clarify that. It's ridiculous. All right. Let's see. Respondent cannot admit nor deny the allegation of the paragraph because it's based on false premise. What is this? Violation of that order. This is a false premise. The respondent was under an obligation to file a motion to seal, so he denies that there was an obligation to seal medical records. No such obligation existed, nor was there any lawful basis for such a duty to have been imposed, nor was there any legal basis to seek an order allowing any documents to be filed under seal. It was Laura's order, or Laura's motion seeking an order for a seal. She wanted everything sealed. It was Laura who asked for everything to be sealed. Like, what is your problem? And then the judge was like, no, we're not going to seal things, but I will tell you guys, can we agree, stipulate, but we're not going to share medical records outside of the parties. Not
that
complicated.
Goes both directions.
Right, exactly.
That's what she said.
Yep. On or about April 19th, he posted the following on his law office blog, which included a portion of one of Owens' medical reports. Guess what Laura's weight was on November 14th? It's right there in the records. It was like 133 pounds or something. Congrats. I don't know what else to say about that.
Weight does not prove or disprove pregnancy. Weight is orthogonal to pregnancy.
Not at all. Yeah. Let's see. April 26th response. They're talking about the expert reports here. He says that, and I'll get down to it, hang on, because I saw this part earlier. He denies that he should not have shared the expert reports. Shit like that. Says that there was no protective order. Hang on. Okay. Arizona's rules of family law procedure require all expert reports to be disclosed in the absence of a protective order. Not on your blog, brother. Disclose between the parties, sure, but not on your blog. There's no law that says you have to disclose expert reports on social media when you've been asked not to share like medical information outside of the parties. But his issue is like he's saying the report from Dr. Deans and the other one, voluntarily consented to the publication of their report because the Arizona rules require all expert reports to be disclosed in the absence of a protective order. There is no law that requires that the public be privy to expert reports, I don't think, in the absence of protective order. I don't think there's a law saying that. And even so, the minute entry with the order from the judge and the stipulation the parties already agreed to covered this. It's really not, I don't think it's that complicated.
It seems like he's arguing that the minute entry is not a court order.
That's exactly what he's saying, and other lawyers that I've talked to disagree. They say that's still a valid thing because the parties agreed to it during the hearing, and he, as her new attorney, still has to follow the rules that they agreed to with the previous attorney. So this is just ridiculous. But yeah. All right, let's keep moving down. So we're talking about the DVRO with Maricini. Okay. He says here, during the course, Echard's counsel disclosed that he intended to call Maricini as a witness. David admits, with the caveat that Mike's counsel later informed him that he was not going to appear at trial in Arizona. Okay, but they're allowed to change their mind on that. Mike is allowed to change his mind on that, especially if he's served with a subpoena. So if Randy Sue Pollock or whatever says Mike's not going to appear, and then Gregg Woodnick serves him with the subpoena, and he's like, I'm going to respond to this lawful subpoena, they're allowed to do that. He's allowed to change his mind and his answer before the hearing. So, CMBBY, thank you very much for the 5 gifted memberships. I appreciate that very much. Thank you. Right. But yeah, that was really annoying. This whole thing was annoying. Respondent understood and believed Mr. Maricini was not a trial witness. No, he knew before the hearing that Mike was going to be a witness. Obviously, he threw a tantrum about it, so he knew. And he did not require Mike to have a deposition. He could have done that. He could have, but he didn't. And so that's not Mike's problem. If he chose not to depose Mike, that's not Mike's problem. If Mike responds to a subpoena that's served upon him, and Mike doesn't know anything about quashing the subpoena, he doesn't want to pay for an attorney to help him quash the subpoena, and he just says, I'm going to respond to this lawful subpoena I was served with, and he shows up in court, he hasn't done anything wrong. Otherwise, anyone who has an order against them or a temporary order could not show up in court for fear that they would be arrested. You can't do that. Anyone who has a TRO who shows up for their hearing to defend themselves in front of a judge for a restraining order could then be arrested. Like, that's not how that works. Everybody knows that people with orders have to face each other in court all the time. There's security there, like, to protect them. They had law enforcement confirm to them that Mike could have been there, and they still threw a freaking tantrum. The judge said Mike can testify. He still threw a fucking tantrum. This is unacceptable in so many ways. Trying to have the witness for the other side arrested is absolutely unacceptable.
They could have used the rule of exclusion.
Yeah. Well, they could have, yeah. And then they were like, well, we're not sure she's going to be able to continue if he's in the courtroom. So ask for the witnesses to be put outside. Voluntarily chose not to do that, by the way. Guess she wasn't that scared. All right. It's almost like she faked it. Neither Echard's counsel nor Maricini nor respondent filed a motion in the San Francisco County Superior Court to modify the terms. Yeah, sure. Okay, I'm not going to get into all this weird bullshit about the DVRO in California because we all know that. Like, this doesn't matter. If you're subpoenaed and you have to show up to court in response to a subpoena, you do it. All right. I'm not fucking with that. Okay. On May 7th, Echard's attorney subpoenaed Maricini to testify as a witness at the hearing scheduled for June 10th. Okay. David denies this. Respondent is aware that Echard's counsel has claimed that he sent an Arizona subpoena to Mr. Maricini at some point. David alleges an Arizona trial subpoena is not legally enforceable outside of the state of Arizona. That's not this bar complaint is about. The bar charges against him, like, don't argue whether or not an Arizona trial subpoena is enforceable. Like, that's not what this is for. Oh my God. I'm not even going to entertain this. Right. Maricini was aware of the paternity case and agreed to voluntarily appear. Okay. Admit he was aware of the case. Allege Maricini appeared on June 10th, but he did not agree to testify at the hearing. Yeah, he did. So here, David says, and he knowingly leaves out the truth, right? He says, he quotes Mike saying, I knew I wasn't going to be testifying at the trial. Here's what actually happened. Like, within 30 seconds of the quote that David is giving. Hang on.
This is in the Megan Fox interview, right? Oh, we can hear the full context. Okay, nice.
Wants to know, did you think you would get to testify in the short amount of time that there was?
No, I knew I wasn't going to be.
No, wait for
testifying.
it. Wait for it.
Her attorney definitely thought I was going to be testifying. I mean, that's why I think he was doing everything he could to possibly rattle me. But I knew it was a slim chance that I was going to be interviewing, and that I was going to be on the stand. And it's just because, like, 2 hours is just not enough time. Like, people.
So his speculation,
yeah,
based on there not being enough time, was that there was a slim chance that he would get to testify. Nowhere in that statement did he actually say, I knew that I didn't need to be there in response to that subpoena. I was not served with a lawful subpoena, or that I refused to testify, or I absolutely would not have testified. He said because of that time. And, like, David willfully omits that in the same way that he omitted that information that he made a complaint about Judge Mata's father getting documents from her that someone else admitted to giving him. Mm-hmm. He omits that stuff on purpose. It's a lie. That's a lie.
Yeah, it's not like there was some grand conspiracy where somebody told Mike, oh, don't worry, you'll never have to testify. Right. That's not the case. It's like you roll into town and you're like, okay, the hearing's tomorrow. Oh, wait, it's only scheduled for 2 hours? And we have Laura and Clayton and 2 medical witnesses and Gregg. Are they ever going to get to me? Probably not.
Well, the thing is, like, just like with Rob's hearing, though, because Rob's hearing was not supposed to be that long. And they had Laura up on the stand for much longer than they were supposed to even have time for the entire hearing. So you never know what the judge is going to do. So he may have said, within 2 hours, I know I'm probably not going to get to testify during the 2 hours, right? But there's a slim chance, and he doesn't know for sure. So he has to attend. He has to respond to the subpoena.
Or maybe everything goes super fast for some weird reason, and there's very few questions, and they get to him, or they put him up there early or something. Like, he doesn't know.
It doesn't even mean jack shit. If Mike thinks he's absolutely not going to be able to testify, if a lawful subpoena is served on you, you have to respond to it.
I mean, it's like insurance, right? You may say, I don't think I'm going to get in a car accident, but you
Right.
get insurance anyway. So you may think I'm probably not going to have to testify, but I better go just in case.
Yeah. Also,
like
people can and do get arrested for dodging. As David points out, people can and do get arrested for refusing to accept services, for dodging subpoenas and for not responding to them. Like it can happen. So it's not unheard of. It's not likely, maybe, but it's not heard of. So it's not unheard of. So like he had to do something about that. And the fact that David tried to have him arrested for it is bizarre, especially when the judge denied his motion to exclude Mike from giving testimony. Absolutely bizarre that he behaved this way. Unacceptable in my opinion. But
I mean, the thing to me that really refutes all his counter arguments here is that Mike was never actually arrested.
Right,
on June
exactly.
10th.
Yeah.
They didn't drag him away for violating this protective order. So It's all moot.
Mm-hmm. He, puts in here something about Miss Pollock and his correspondence. Miss Pollock, who was Mike's previous attorney. I don't think we need to really go through all that. He was just saying which sounds kind of almost extortionate when he's saying okay, well, if he, wants to talk to me, then I won't try to have him arrested. Like that sounds a little questionable to me. Maybe not outright, but it's questionable, at least to me. And he, says this, of course, if he will talk to me, then he can testify and that'll be fine. Right. And so if he can talk to you and all of a sudden the state laws don't matter and he can go testify, then why are the state laws important at all?
Yeah, he was complaining that nobody modified this DVRO,
Right.
but he was prepared to do an interview and let him testify without modifying the DVRO. So it's like he's trying to have his cake and eat it too, which doesn't make sense to me.
And at that point, he could and should have deposed Mike, tried to depose Mike, compelled Mike to attend a deposition, and he chose not to do that. Don't know what else to tell you, man. That's your fault. Bruce, it's your fault. If Mr. Maricini intends to testify, blah, blah, blah. So he sends this long ass email, which is just rambling like he would on his blog. Respondent further affirmatively alleges he made multiple attempts to negotiate with Mr. Echard's counsel to ensure Mr. Maricini could appear and testify at trial. So the thing is, what do you mean negotiate with them that he could testify? They subpoenaed him to testify. It is up to Mike then to get to trial and do his part. It is not their responsibility or obligation to negotiate with the California DVRO. So why are you talking to Gregg Woodnick about this? Why are you bothering him about this? Okay. Respondent told Mr. Woodnick that as an attorney licensed to practice in California, he would agree to prepare and file a stipulation with the California court, which would modify the existing DVRO to allow Mr. Maricini to travel to Arizona. So my question is, why is it that Mike didn't need a stipulation to attend court for the renewal hearing if Laura was going to be there in California?
In California.
Right. Why did he not need a stipulation to attend?
Interesting.
Because she has a DVRO. It says he can't be within 100 feet or whatever of her. Why did he not need a stipulation to attend the hearing?
The only thing I could think he would argue is that because Mike was one of the two parties in that case, as opposed to just a witness. But I don't know that argument.
Just a witness doesn't really mean it. You know what I mean? That doesn't really mean anything to me.
I don't know if that argument holds any water.
Still, both of those things to me mean required to be in court. So,
right.
And apparently the bar agrees. So, all right. Anyways, they talk about how he was in the parking lot and how David called security, then called the police. We don't need to rehash all that. We kind of know how that went. Respondent argued non-disclosure as a basis for precluding Maricini's testimony. Okay. Judge Mata affirmed her prior ruling allowing him to testify. Then David says, to the extent the reference to her prior ruling refers to the court's prior rulings on issues other than the DVRO, he admits that. And then he says, with respect to the DVRO issue, that issue was never briefed prior to June 10th. So why not? If it was such a big deal, why didn't he bring that up with the court before June 10th for the judge to rule on? That sounds like a you problem. So, All right. Maricini was sworn to testify in court, but never testified. Yeah. Okay. Respondent knowingly made unprofessional, disparaging, and inappropriate comments about Judge Mata's qualifications and/or integrity in documents filed with the court and in posts he made on social media. He admits, of course, to making those statements. He affirmatively alleges every statement he made was factually true or was made with good faith basis to believe it was true or was an opinion protected by the First Amendment. So there are matters of opinion. Like if he wanted to say something like, I don't think Judge Julie Mata did a great job in XYZ matter, maybe, I don't know, because lawyers are held to different standards. So there's things that I don't understand about what a lawyer can and cannot say about a judge in their case. But I'll just say it this way. There are matters of opinion. Like, I don't think Judge Julie Mata handled XYZ thing correctly. And then there are matters of incorrect fact. Like, Judge Julie Mata committed a crime. You know, you can't just go around accusing people of crimes in court documents and like matter-of-factly accusing the presiding judge in your case of crimes with no factual basis for that. And then be like, well, I had a good faith basis belief to believe it was true because she ruled against me or because I think that's true. Like, what?
Or it's a protected opinion. I mean, the problem with this First Amendment thing is like, at some point you have a job, right? And you're, regardless of your First Amendment rights, your employer can fire you.
Well, that's kind of where we're
the bar is effectively as close to an employer as he wants.
Right.
And if you say, well, you know, the feds aren't allowed to silence me because that's a First Amendment right. I mean, if the feds are your boss, I think they can still fire you. That's not exactly a First Amendment violation.
Yeah, right. Yeah, so he's kind of that's kind of where we're getting butting heads here, I think, between him and the bar. It's like, you can't do that within the bounds of your profession when the judge presiding over you is effectively, yes, like you said, you know, kind of, or the bar or the judge is like your boss or like somebody above you, right? And you can't act unprofessionally like that. But then there's like, okay, but this was my free speech, my rights. But like, we all have a right to go on social media, I guess, and be like, my boss is a fucking bitch. But you might get fired for it. So like, yeah.
Yeah, exactly.
Yeah. My boss is not a bitch, by the way. Sorry, Joe.
That's a hypothetical boss.
No, my bosses know about my shenanigans here. I don't care. They know I'm not talking about them. So, all right. On July 8th, respondent filed a notice of change of judge, right? All of that. He admits to making the statements, alleges every statement he made is factually true. Again, you're going to have a really hard time convincing people that everything you said was factually true or that he had a good faith basis to believe it was true. Good faith basis seems to be a challenge for David. He seems to not understand what good faith basis means. So, all right. Sometime prior to September 3rd, let's see, which was during the appeal, he posted, you know, something on his social media. I don't know exactly what the text was, but he says, I admit to making these statements, but he still says there's a whole like factually true. Respondent's comments pertain to Judge Mata's inadvertent reference to an incorrect family law. Oh, this is the one where he said she fucked up the law or whatever, screwed up, or he didn't say fucked up, but like that's how I interpreted it. He said she screwed up, or she unsurprisingly she made a mistake about this law or whatever, and then she corrected it, right? It says respondent's comment pertained to Judge Mata's inadvertent reference to an incorrect family law rule, which sometimes people get the numbers wrong. It happens. Like they get the number or the citation wrong. It wasn't a big deal. She fixed it, right? And the final judgment language in her June 18th ruling regarding the hearing. And then she corrected that error on February 18th after the Court of Appeals remanded the matter to the Superior Court. And he denies that for some reason. I don't understand the point of denying that, because that's what happened.
He's denying that his comments from 103 have something to do with the events in 104, I think is the idea here.
Okay, how about this?
And it's like, I don't know if they're related or not. I'd have to go reread whatever the text from 103 was.
Oh, I'm going to find out right now. Hold on.
Yeah. Anyway, I think I have to take my dog out.
Do it.
Let me return momentarily, if you're still going.
Don't you dare come back here. No, I'm just kidding. Sorry, guys. I'm trying to figure out what 103 said here. Okay. All right. This was the complaint. 103 said, sometime prior to September 3rd, respondent posted on his law firm or personal blog Exhibit B. All right, let's see Exhibit B. The notice of appeal must be filed within 30 days of the judgment. Annoyingly, but not surprisingly, Mata screwed up the form of final judgment. It doesn't contain stuff required by the rules. Shocker. We could ask her to fix this, but that would be a waste of time. Okay. So, his comments pertain to her inadvertent reference to an incorrect rule. So she, messed up the citation, messed up the rule, whatever. Okay. She corrected that error after the Arizona Court of Appeals remanded the matter to Superior Court. And he denies that. I'm confused as to why he's denying that, I guess. That's the confusion. So maybe there's some technical thing here, but I have a hard time believing that if there was a further explanation, he wouldn't have vomited it out on the page here. I don't know. Rob's trial was bullshit. Rob got robbed of a defense. Rob's lawyer was not great, man. I'll tell you that much. I found it entertaining to see David stand up and be like, don't stop calling her a cunt, stop calling her a whore, stop making these comments. When David has said that I have a sex tape with Clayton and made weird comments about me like that, when he said some pretty profane things about me, about other people, and behind the scenes said some even more profane stuff, which I won't get into, but ooh, yikes. Yeah. So I don't know. Not a fan of either attorney in Rob's case. Let's put it that way.
Oh boy.
Oh, you're back. So I found the citation there. It says, here's the citation. He denies this, that she corrected this after the Court of Appeals remanded a matter to Superior Court.
Well,
Okay.
I think he's denying that his comments relate to that event.
Well, I don't know. Let's find out. Notice of appeal must be filed within 30 days of the judgment. Annoyingly, but not surprisingly, Mata screwed up the form of final judgment. It doesn't contain stuff required by the rules. Shocker. We could ask her to fix this, but that would be a waste of time. Okay. Comment pertained to her inadvertent reference to an incorrect family law rule regarding the final judgment.
So it seems like it is related to this.
Yeah.
I don't know why he's denying it. He didn't explain it.
That's a little confusing.
Why, if he had more time, why would he just say deny instead of explaining why he denies it?
That's what I'm saying. I feel like he wanted
rationale there.
He wanted to attack his adversaries more than he wanted to present an effective defense. It feels like. I'm just kind of like, your lawyer should have done this for you. And you should have taken your time.
Yeah. I mean, this is a lot of, we're on 104.
Yeah, right.
Life is slipping away from us all while we read all these items.
So there's, stuff about Judge Mata committing a crime on here. He says that he admits that he published his statement. Let's see, but denies the statement was solely limited to Judge Mata committing a crime related to her alleged failure to enforce the DVRO. For instance, although Judge Mata committed a federal crime, blah, 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 he's still accusing her of crimes, by the way.
Oh, boy.
And it's up to the judge to decide these things. So this is ridiculous.
Yeah, I mean, she hasn't been convicted of any crime.
No.
She hasn't even been indicted of any crime.
Right. And this is more like he is speaking his opinion, right, that she has committed a crime. He thinks, based on his knowledge, that she's committed a crime. Yet he threatened me for saying, I think some of your behavior concerns me that you might be on drugs. Based on my experience, I feel like that might be what's going on here. So in one case, he says it's like free speech and he's defending himself on it. But the other one, it's like, I'm going to sue Lauren. I'm like, okay, can we be a little consistent here with the what constitutes free speech? He seems like a bit of a hypocrite. I don't think he's actually a free speech lawyer at all. But okay.
Now, Lauren, we have to start over from the very beginning of the document because Omar's here and he's missed everything up till now. So.
Okay, suck it. I don't know what else to tell you. I'm not going over all that. Yeah. Anyways, so we're gonna continue on. For instance, although she committed a federal crime here, she also committed other crimes, including a violation of 18 U.S.C. 1513, which she violated by retaliating against me for contacting law enforcement to report the possible commission of a federal crime by Mr. Maricini.
Oh
Dude,
boy.
it was witness intimidation. It's not because you called the police on someone who needed the police called on them. This is not complicated.
What is this retaliation? A bar complaint?
Yeah, apparently that's the retaliation, which is like, how many people have retaliated against you now? Like 24? I don't know.
I mean, is it retaliation? I don't.
Yeah. He said your Google's not a
Judge
valid...
Mata's not his
evidence.
boss. Judge Mata doesn't have any power to, retaliate against him.
Yeah.
Like, you can't take Fridays off anymore. That'd be retaliation.
Just talking more about the statements he made about Judge Mata here, which he admits. Let's see. Based on the conduct, he violated the ER 4.4a by using means that have no substantial purpose other than to embarrass or burden Judge Julie Mata by making a statement with reckless disregard as to its truth or falsity concerning Judge Mata's qualifications or integrity, by engaging in conduct prejudicial to the administration of justice, and by failing to maintain respect due to the court and Judge Mata, and engaging in unprofessional conduct. Unprofessional conduct is like a pretty wide berth, I feel like.
Do we need to get Omar a link?
Oh, I mean, we can if we... Oh, yeah, okay, hang on.
Yeah.
That's a good idea, so I can take a break. Hang on. I'm going to email it to you. One sec.
Do we have to read the whole document tonight?
Fuck that. No. No. Well, we'll finish it because we're already on page 41 of 69, and a lot of it I'm going to skim through the rest of it. There's only one more part I really want to get into, which is when he accuses of Dr. Deans of perjury.
Oh, yeah, that would be interesting to look at.
Yeah, we'll do that.
I don't know.
But yeah, okay. So until Omar gets in here,
just don't let me and Omar digress too much about shoes or something,
Yeah, that's what I want to do. Okay, all allegations set forth. Here we go. On November 21st, he sent an email to Laura and copyright at Reddit, which we know about that. He was trying to copyright strike the Redditor who was reviewing his videos, which is embarrassing in and of itself, by the way, as a free speech attorney, nonetheless. But he sent an email to them, and he, in that email, identified himself as a lawyer in Phoenix, so was acting as an attorney. So identified himself no less as an attorney representing Owens in her legal case against Echard. So identified himself as a lawyer in that context. That email message stated in part, Clayton's fans, being the total fucking assholes that they are, have come up with a new plan. So he's talking as Laura's attorney in the context of their case and criticism about that case.
Oh, he's talking about us, Lauren. We're the total fucking psychotic assholes.
Well, I knew that already.
The TFPAs.
Yeah, okay. And he defends himself on that a little bit more when we get down the document.
So wait, this is a charge from the bar. So that's justice for us. That's justice for us, Lauren.
Yeah, right. Yo, what's up?
Earmuffs, Bruce.
What?
Hey, I got the littles in the background. Oh. I'm gonna go stand over here by the stairs. As soon as I walk in, like he's dropping an F-bomb. It's like, this is a good start. I know I'm like an hour and 42 minutes late. I'm just saying.
Have you met David Gingras? Do you think he might call us some naughty names?
Oh, I'm well aware of Mr. Gingras and the fury that he inspires, to say the least. So yeah, I haven't read these complaints and I haven't read his response. I've caught wind of his meandering rants. And I'm not unimpressed with some of his beef. I'm disinterested in a lot of the other stuff. And I know that he's got this motion to dismiss that he's fighting. Although, does anybody have a copy of that? Like what Jim is actually saying?
Saying about what? The
motion to dismiss on the pleadings. Yeah.
I don't know. He just mentioned that like an hour ago. That's the
and
first
I have no idea. Again, I apologize if I'm like derailing the stream. I won't stay for very long.
Well, how about this? You stay and talk to Bruce while I go to the bathroom, please.
No, it's all good. I think there was a new blog post today. A second one, right? That's the one you're talking about?
The one where he talks about Jim's motion to dismiss on the pleadings.
Okay.
And what I feel like that probably is just an effort to try to reduce down the issues
Mhm.
Like he's cooked on some issues, but not on others. Because Gingras' big thing, without reading any of his response or anything that you guys have went over, is that there's genuine disputes of facts, which may be true, and I don't even know, I haven't even read the complaint, so I don't know like what percentage of this is based on free speech, in which truth would be a defense, and what portion of the complaint is based off of just pure ethical
Oh,
misconduct.
not very much.
And to the extent that he's admitting that in truth isn't a defense, then potentially
Yeah.
those are dismissible. And so
Yeah.
again, haven't seen anything. I'm going out on a limb and saying that's probably what's going on.
So I don't know if you can see the screen, Omar. But what we've got are all of the individual charges and then the response. So
Yeah.
it's like every single one is a particular allegation, and we're up to 118. So it's 118.
Jesus
And
Christ.
depending upon which one it is, he is either admitting or denying, or admitting with clarification, or denying with clarification, each one. And some of them he's explaining. If he admits with clarification, he says, sure, that's true, but it's in the context of XYZ. Or if he says deny, he may say, I'm denying this because here's my argument, right?
So context does matter. I heard he didn't like my context argument when I
Yeah.
critiqued his
But
free
the
speech.
problem is a lot of these just he either says admit or deny without
Yeah.
further explaining too much. So
Well, honestly, that's
I
probably
think-
what he should do. You know, it's fine
Well-
to explain the things that
Yeah.
he's admitting
Mhm,
and giving context. Like that happens.
mhm.
It's not like general, like I deny all the allegations against me, whatever he's being forced to admit or deny. That means he's responding likely to a verified complaint by the bar guy. And so if he's admitting something, it's his right to give context. So there's nothing wrong with that.
Mhm.
Now, I don't know what he's going on about, so I have no idea if he's giving too much context or burying himself with some of his admissions. You know
Yeah.
what? It sounds like a good thing that I should probably do a live on, huh?
Yeah,
I wasn't
it
planning on
does.
going live tonight, but I kind of want to get into this myself and look at some of these things.
Because Lauren and I can go over the details of things like, okay, what happened on June 10th? Did Laura say this? Was Mike Maricini in the restroom? We can do all that. But what's really interesting, I think, is this process.
Mike was
of this,
taking a huge dump.
oh boy.
Oh, Jesus Christ.
I think what we can't do that you could do is explain sort of the process of, okay, the bar has the power to do XYZ. And so they filed this, and then Gingras has to respond. And here's his response, and whether you think it's interesting or not. What is the flow of the process and what we can expect? That would be very interesting, I think.
Well, I've never defended a bar case or a bar trial like that.
Yeah.
And so I can only assume if they're going by the civil rules that it's substantially the same. I am curious how they're getting my understanding of reading David's blog with respect to, like, for example, the Mata deposition is that their position is that they don't have to produce certain things without a court order. And then David's upset about that. But then I think, wouldn't the response be to go and try to get a court order? Like, they're not saying that he can't do certain things. Like, if a court order is what's required,
Yeah.
then get the freaking order. I think he's trying to argue that a subpoena by itself is a court order. Well, maybe, but why don't you cover all bases, since maybe he's not as experienced as he thinks he should be with respect to how these bar proceedings go.
Why would that be a
And-
court order though if it's issued by an attorney and not signed off on by a judge?
No idea. I don't know how the state bar conducts their trials. I was confused by it myself, if I'm being honest, because normally if David has a point, there's a factual dispute with respect to a witness. This witness is listed on the bar's stated witnesses. And so presumably they're going to be asked questions about some of the complaint, and he would normally, under any other circumstance, have the right to depose that person. I don't disagree with that position. But then I haven't
Well,
read
maybe-
everything
Why didn't he
that's
ask for
going on.
deposition? Why didn't he subpoena him for a deposition?
Who?
Are we talking about Mike still?
No. I'm talking about Judge Mata.
Oh, fuck that. No.
Okay.
I wouldn't. I would dodge the shit out of that if I was Judge Mata, because I'm scared he's going to come and, you know what? I don't need to say that out loud. I'm scared he's going to do something to me. Let's put it that way. He's scary towards her. So, like, if I were Judge Mata, I'd be like, yeah, I absolutely don't want anything to do with you unless I have to. And I'm also not going to willfully walk into the hallway where you may be lurking because you talk about me in a way that makes me feel like you're fixated on me and you might want to hurt me a little bit.
I'm highly skeptical that Judge Mata is dodging a subpoena, just because if that's the case, I'd imagine she just accepts it and then moves to quash, if it's quashable.
I don't know what she should probably just have someone accept it on.
I don't think Judge Mata has anything interesting to say for this investigation.
That's the other issue.
The only thing we don't understand really from Judge Mata is, where did this Planned Parenthood closed on Sundays thing that's in this final ruling come from? And number one, it's immaterial because we never got an ultrasound from a Planned Parenthood to the lawyers. So who
I thought
cares?
it was I thought it was like in a deposition somewhere.
Well, I thought Bruce told her. So.
Well, here's the thing. I don't think it matters. Let's say she gives you an answer.
No.
So, like, then what? Like, it doesn't matter, right?
Well, because look,
what do you do with that answer? You can't do anything with it.
Your instincts are correct, because it's like, all right, so she happened to have outside knowledge. The question is then, all right, so she either had a general knowledge of that as a fact, or she heard it somewhere else. Either way, he could suspect that, she was on some secret mission to investigate secret facts regarding the case that would necessarily be dispositive of the case, and that's how she came upon the information. Or in the course of being the judge for this trial for 9 months preceding the trial, maybe it came out somewhere in the record, or perhaps it came out in I don't know. It happened, but
she was asked to take notice of his blog, and in his blog there were comments stating that Planned Parenthood was closed on Sunday. Not in his writing, but in his comment section.
Well, that's assuming that she's reading his blog, though. It's making a lot of assumptions.
She was asked to do that, though. Like, she was asked to take notice of his blogs.
Fair enough, but my point is that his conclusion is that she's conducted illegal, independent research into a case, but he has nothing to prove it other than she happens to have known this one fact, this one mundane fact that was cited in her ruling in a case that was litigating necessarily the operating times of Planned Parenthoods in multiple locations. And so even if you accept, those arguments, and he wants to make that inference, there's nothing, and he's not going to be able to prove, no matter how much he jumps up and down and screams, that she did something illegal there.
I don't know. He could try. Well, we could see if he would.
Well, he is trying. He's very clearly still trying.
Yeah, but like harder. You know what I mean?
He could try super hard.
Yeah.
He's going to jump up now really, really high.
So this thing Jim Lee filed, that it's nice of him to tell us that he filed it, but it's a motion for judgment on the pleadings. So my interpretation is that because there's out of this, what is this, 69 pages, and there's 100 and blah, blah, blah items, and he just puts admit next to some, with no response, next to some number of them, which seems to be like a large number of them. Maybe the argument is like, look, there's enough of these where he just agrees, just go look at those and rule on sanctions or whatever they're going to do to him.
I'm willing to guess if you see
that correct?
Admit. No, well, I'm guessing if you see admit next to something without context, he's probably admitting like stuff that, yes, my name is David Gingras. Yes, I'm a practicing attorney. I admit that. I admit that I was an attorney, lead counsel for Laura Owens. I admit that I was involved in. Oh, am I wrong?
There's a lot of them that are more than just perfunctory. Like, we're on this 121. And
maybe I should read the freaking thing then. How about that?
Yeah.
Without talking out of my ass.
Because there's some of them where he just sort of admits it, but it's one of these things where from his point of view, it's not wrong to do the thing that he's admitting to doing.
On free speech ground? Give me an example of the most egregious one.
Well, we don't know what his argument is, because some of these just say admit or deny without an explanation. Some of them have some arguments.
I see. I can't really answer your question any better than I am, which is talking out of my ass right now because I haven't read anything.
That's fair. I mean, I'm trying to just, give you the context of what we have here so far. We don't have everything. We don't have this motion for judgment on the pleadings yet.
Sure. I feel like just listening or reading David's blog, most of his defense is going to be he's treating this like an anti-slap case.
Yep.
And therefore he's gonna fall on the sword that, yeah, I said it, so what? It was true. And that's the ultimate defense. However, some of the stuff might not be based on things that he said. It might just be based on his conduct.
This shit about like him not doing his due diligence, where he's like, I deny that I didn't do my due diligence, but you obviously didn't do your due diligence because you stood up and said this was before my time and are pretending that you had no idea about this stuff. And then he's like, well, that was immaterial. That didn't matter. But it actually did matter. It did matter that he paid attention to whether or not an ultrasound was false. That was a material issue.
Well, for his sake, if he's going to say it's before his time and then after the fact become aware of the thing that was before his time, he better damn well hope that it's immaterial, because if it is material, then yeah, he's not prepared for trial.
Well, it's material enough that she has 14 felony counts from a grand jury. That's pretty material.
Isn't one of the complaints that he knew about bad stuff that was being filed and failed to not defend Laura Owens a certain way or something like that? Like he purposely knew that exhibits were false and submitted them anyway. Isn't that one of the complaints?
Well, the affidavit is one of them.
To some extent.
Yeah.
And again, take everything I'm saying with a grain of salt. I've read zero of this. I'm getting this all third hand.
You'll have to read them, because like earlier there were two where I thought one from the bar was pretty strong, but the other one was a little weak because they didn't completely explain it. And they may be able to explain it, but I just thought the way they wrote it was a little weak. What I wanted to ask you, Omar, before you have to go or anything, is he spends a lot of time defending himself by saying, well, the problem was Woodnick. Woodnick wouldn't do this, or Woodnick lied about that, I think. And so he's trying to defend himself by throwing someone else under the bus. What is your take on that?
I don't know what that's even in reference to. Woodnick wouldn't like meet and confer with him about certain things.
Yes.
Is that what it is? I mean, I happen to have seen some of the internal community. Well, listen, I don't want to say too much. I've seen the old case files. Mm-hmm. And from what I know, I have reason to believe that they communicated quite a bit.
They did. I read all that stuff yesterday. He said, I will go to lunch with you after you guys make the disclosures that the court has compelled, because our experts cannot make their expert reports until you give me that information, and therefore we cannot discuss it, so there's no point in meeting until after you give me that information.
And the thing about David is he's the kind of guy that will call you on the phone. Not everybody likes to talk on the phone. Like when you can just send me an email and I can get you what you need.
Nobody wants to talk on the phone.
I tried to do that once with him, and it ended up in a 66-minute phone conversation that was well documented. All I'm saying is he might have been sore that Woodnick was not answering his phone calls, that he didn't want to go to lunch with them, that he didn't want to do this and that. But it's also quite possible that whatever it is that he was trying to gather was sufficiently exchanged within emails.
He literally said that he would go to lunch with him. They just needed to disclose the information first so that they could discuss the actual issues.
I don't know everything about that case. I know that there were a lot of things disclosed. I know there was a lot of evidence going back and forth between the two.
I just read this shit yesterday again.
The thing that blew my mind was his claim that he believes Laura is telling the truth about being pregnant from Clayton because of Woodnick lying to him.
Doesn't make any sense to me.
There's no causality there.
I've been hearing the whole Woodnick is a liar thing for over a year, and it's never made sense. I've always asked, so what was the lie specifically? And nobody's ever been able to pinpoint it for me.
Well, I could tell you right now. He says that Woodnick lied about Laura not complying with Rule 49 disclosure for 8 months because it was actually 7.5 months.
Oh God.
Yeah, bro.
Let's call it substantially telling the truth then. How about that? Substantial compliance.
Well, the problem with Gingras's filing here is he didn't actually compute the 7.5, like to refute the 8. We computed that number.
But the thing with Gingras is, like, he'll take something like that, and like he'll say, "Listen, you might not be a lawyer. If you're a lawyer, or if you're not a lawyer, you might not know this, but there's rules. And let me tell you, there's rules. And when you make a representation of the court, then it is like you're an attorney and you took an oath and you were there to tell the truth. And God damn it, if you say that you complied and it was like a 9-month thing, then that's what the court takes as truth. But guess what? If you misrepresent it, if you're not a lawyer, you wouldn't understand this. So just take it from me that when you misrepresent yourself to the court, you're as good as, you know what, you should go to jail." He says 7.5 months. It was actually 9 months, and that's bullshit. He should be disbarred. This whole thing, I'm putting the whole system on trial. Everybody's out of order. That's a David Gingras argument in a nutshell.
Sure.
Well, by that argument, he should go to jail for this $450,000 money market account thing in the affidavit that is refuted by the bankruptcy hearing.
Right.
I don't know much about the bankruptcy case, but my understanding of the bar complaint, and correct me if I'm wrong, is some of this has to do with his continuing to say that Mike violated DVRO by showing up as a subpoenaed witness, and he is continuing to die on that sword. I feel like there's a level of competence that is required of an attorney. In every courtroom that question has ever been posed, including Mike's in California, including Mata's in Arizona. I don't know where else it's been litigated, but they've all said the same thing. Like, look, if it's a subpoenaed witness, he's allowed to be there. Like Laura Owens herself, like, tried to make this argument that he would be violating. I think she was talking about, I forgot, we called witnesses, there was restraining orders. They'd be in violation of restraining orders if they came here as a witness. And the judge literally said, they can be here. We got a bailiff. You're going to be safe. We can make accommodations. And then I know that something similar happened in the Echard trial. And I'm just going to go out on a limb and assume that some of the lies that Gingras is claiming Woodnick made are in relation to the conversations that were had prior to that hearing, specifically surrounding whether or not there was violations of DVROs for subpoenaed witnesses. And if he's continuing to make those statements, and maybe that's one of the things that he's admitting in his response, I don't know. But if he's going to go before the state bar in Arizona and continue to make that claim and say that he's entitled to make that claim based on some mundane legal argument that nobody will ever accept as being based in fact or law, then he's got problems, man.
Yeah, he's mostly making the legal argument on the DVRO thing.
Yeah, but the legal argument is so egregiously bad. It's just, it's not.
I get it. Like he said, hey, you know, if you talk to me and do an interview, we can go get the DVRO modified so you can go to Arizona. Now,
I remember that.
Omar, did you guys get the DVRO modified for the San Francisco DVRO renewal hearing?
No, I didn't have to do anything like that. The judge straight out said, look,
why were he and Laura complaining about Mike for June 10th, but they weren't complaining about Mike for the San Francisco hearings?
Well, I think the judge shot down Laura's argument in a pre-trial hearing because she tried to make the argument that she can't be present in court because of the restraining order against Mike and other of our witnesses. Our other witnesses happen to be Gregg and Clayton and Toe. And the judge, she's like, look, because she was well versed in that argument based on Gingras's extraneous filings in that case, if you recall. She straight out said, look, he's a subpoenaed witness. He's allowed to be here. We got bailiff. There's no modification of DVROs. She was ordered to be present. Her request to appear via Zoom was denied. She was a part of the case. Yeah. And was just not a legally sound argument. And the judge shot it down right away. Yeah. She didn't get to finish her argument.
Your judge did what Judge Mata did, and then Judge Mata reaffirmed her decision on June 10th. So,
but in Judge Mata's case, it's my I mean, I don't want to speak out of turn because I wasn't there in Arizona, but it's my understanding that they actually had an in-chambers pre-trial meeting addressing that specific issue. And after all of those issues were addressed, that's when phone calls were made and all the rest kind of just went to shit. Now, don't quote me on that. If I'm incorrect on any of that, I'm
really?
going off the top of my head off of memory. It's
I
just
don't know. I think it would have been after the phone calls were made. It may have been
after
after.
what?
Yeah, I don't know the order there.
The meeting that may have happened after the phone calls.
Well, that's what I'm saying. If I'm wrong, don't take that when I'm going off of memory, and my memory is not perfect. And I haven't thought about those facts for months. And so all I'm saying is they for sure 100% had conversations about accommodations because it was a thing. And
Yeah.
I don't want to speak too out of turn because I haven't reviewed these facts in a long time. I don't want to say the wrong thing. All I'm saying is it was an issue that was addressed at that hearing. And if he's still going on carrying on this argument, and he's really going to die on this sword, then I think that's going to be a perfect demonstration to the bar about whether or not he's professionally competent for one, whether or not he is fit for being an attorney for two, along with all the other ethical violations that he's facing.
Well, Tiff says it was before the phone calls too. So.
Yeah, that's what I
I mean,
suspect.
I have a
But-
timeline. I'll go review my timeline, but again, I'm talking out of my ass.
But either
Because to say not
way,
with my notes in front of me.
previous to June 10th itself, there was documentation that witnesses could attend.
Oh, yes, there was. There was
Yeah,
communication. There was emails back and forth. There was statements that if you do this, then I won't.
Yeah.
Then I'll agree that it's not a violation of anything. And there was a lot of back and forth. The point is, I think what's interesting to the bar is that it appears that through the weaponization of an existing DVRO order for a witness that was subpoenaed, even as a friendly witness to Echard's team, that he attempted to weaponize an out-of-state court order to intimidate a witness. I think that's the deeper question for the bar that they're trying to contend with. And I don't think that you can argue right to free speech in that defense. If that's indeed what they're asking. And again, I haven't read the complaint. I should probably just do that before I jump on the line with y'all.
Because I think that one's less about free speech and more about legal process.
It's about
and
legal.
the- and
It's
the
about
rules.
conduct. Yeah, professional responsibility, conduct, and the whole nine.
Mhm.
Yeah.
And to me, the whole thing here is there's so many claims. Oh boy, they're going after him on all these different vectors. There's the Judge Mata vector. There's the Mike vector. There's the calling us TFPAs. There's all sorts of problems here.
I just think the lack of due diligence, especially here in 120, you can see as well. Like the March 27th letter from Woodnick to him placed him on notice that he needed to be diligent in ensuring that Owens was truthful about her health, alleged pregnancy, medical records, and events, and determining whether any legitimate evidence existed, reflecting that she was pregnant and Echard was the father, and he denies that. So he consistently is like, no, I didn't need to know all that. No, that wasn't important. But
That's
like, it kind of
ridiculous.
was. Right, exactly. And that
is
to me is
ridiculous.
like the kind of the that's kind of the heart of the complaint to me.
What's funny is he
because some of
knows
the stuff
that,
is
because-
like with Judge Mata and with the Reddit stuff, it's like, yeah, that could be free speech. I guess you could see that with the Mike stuff, and maybe you could argue that maybe he really thought. Even I don't believe he thought that. I think he was just being an asshole. But maybe he could argue that he really thought that he was doing the right thing there. But when it comes to the due diligence stuff, he's fucked.
The due diligence stuff, he literally just made a video where he basically just said that, look, he was responding to the video that I made about his, where I said a lot of nice things about Dave. I thought he did well in that trial. But he was saying that I was once that attorney that sat with this case for 2 weeks, and I was the new guy and I didn't know anything. And, because I had made statements that this guy's not prepared.
Mm-hmm.
And so he understands the importance of, look, you're taking on a case, you're going to trial, you don't get to say before my time, especially for facts that are material to the case. And I know that didn't he try to get the trial continued at some point, recognizing that, hey, I don't got enough time to prepare for
He
this.
asked for an extension to respond to the motion to compel for stuff that Laura had said for the first time in her deposition. I don't know that he actually tried to get, he might have, I just can't remember if he actually tried to get the hearing pushed. I know that he asked for an extension to respond to some things when he first came on the case, but I don't remember if he
Hey
asked
man,
for
if I was taking on a case like that, I 100% would have asked for a continuance. I don't think I would have accepted the case.
He was denied his continuance, but yeah.
I swear, I wonder if I'm imagining it. I swear I thought I heard him say once that he tried to get the thing continued because he was just coming in and he fully expected his request for continuance to be granted. And then the judge said, no, we're doing this in June.
The motion to compel, he either had to like respond right away or to get an extension. He asked for an extension. That's when he first made all those weird arguments, I think, about like Trump and stuff like that in his motions. And I think that the judge was like, no.
Which, by the way, reading his blog today, it made me laugh because he said, like, he brought this up to some friend of his, and then the friend was like, "Hey, on a scale of 1 to 10, how fucked are you?" And then he's like, 0. This motion is bullshit. And it's like that's exactly what Donald Trump would have said.
Yeah. Right.
Hey, so if it appears like we're going to put troops on the ground, what do you say about that? This war is over. Well, Russia just got in. It looks like we're going into World War III. No, it isn't. Also, Iran is dead, and I've sunk in all of their battleships. The war is over. Also, there might be a draft. Well, never mind.
Omar, here's the thing. In I think the previous blog, he said he's just got to get his roof re-roofed, and then he can get out of Arizona. If he leaves Arizona, isn't it sort of irrelevant what the bar does to him? So it's kind of true. If he's already accepted whatever fate the bar is going to throw at him, and he's going to leave anyway, maybe he just doesn't care.
Well, I've been of that opinion for a while now with him. Like, I feel like, in my conversations with him, there were times where he felt resigned to his fate. And I think that right now, it's more or less he's going out like a dying star.
Posturing.
Yeah. And he's going down with whatever he can. He's going to put up as much of a fight as he can. And he's trying to subpoena folks, and he's furiously blogging away. And so he's going down fighting. That's what it feels like.
I really think that he should have had his lawyer do this response for him.
Oh, maybe he couldn't afford it.
I don't know. I mean, his buddy's doing it for him, so he's got Randazza representing him apparently. So
for free?
Oh.
I don't know if it's for free. I have no idea if it's for free, but still, I don't think that money is an issue. I think that he just did this out of rage because he said he had, I don't know how much time to respond, but he did it within 2 days and he responded himself. I'm just like, you should have had your lawyer do this, man.
Yeah. I mean, he's also welcome to write his own declaration. He doesn't have to write his own filings, and so he could rage all he wants in his own declarations or on his blog for that matter. And that's the thing. He's continuing in this. Well, I don't want to say too much. I don't want to make it free.
Like somebody needs to take this guy's keyboard away and be like, "Let me help you." It's like, even if I were Mark, his friend who's representing him, I'd grab him by the shoulders and be like, "Dude, let me do this because you're not sounding right now. Even if you're right, you're not sounding right now. So you need to let me help you." Like, that's how I would feel about it. So
I feel like there's probably been a lot of people in David's life that have tried to do that with him.
Yeah.
To no avail.
Mm-hmm. Well. Oh well. Let me see if I can.
What do you think about that? Anyway, I'm going to let you all go. I didn't mean to derail your stream.
No, you're good.
I'm seriously considering starting my own stream in about 40 minutes or so, of which either of you all are welcome to join, but I reckon you're probably going to be too exhausted to sleep.
Yeah.
But just know, it's going to be completely unprepared. I'm probably just going to read the shit live and give my real-time reactions.
Yeah.
Because there's enough smoke going on that has got me curious.
Yeah, I gotcha. All right, we'll try to read.
I got to put these girls to bed.
All right, we'll talk to you later, man.
All right, folks. Bye-bye.
Bye. Okay, so I'm going to skim through some of this stuff, so it's not really necessary for us to read every single one. So the thing with the Planned Parenthood portal, he admits he logged into her Planned Parenthood portal, her patient portal, so he would have had access to like all appointments and records that she had from Planned Parenthood. And then we get down to like where they're saying that he should have known these things about the Costa Mesa location, and the what she said about the Los Angeles location did not reflect an appointment at a Planned Parenthood location in Los Angeles. He says due to the amount of the time that passed, he blames the bar caused by unnecessary delay on the part of the state bar. I don't know what took them so long, but they did a pretty thorough investigation of many complaints, dozens of complaints, I think, almost, if not actually dozens.
Yeah. In this 127, does it say what's in this portal?
I don't believe so. Reflected in appointments. So like the appointments would be listed in there, and then any records or notes from those visits would be listed in there.
Oh. So
and
there is an appointment at Costa Mesa.
Right. So she made an appointment and she did not attend.
Okay,
I
so
believe
that's
there were 2
basically what's in
weekends.
her patient portal.
Yeah, I believe there were 2 weekends she had made appointments in California that she did not attend, like she did with Dr. Higley. Or like other specialists too. I think Dr. McCool, Dr. Higley, she's like, they're my doctors, but like she never actually saw them. You know what I mean? So she did the same thing with Planned Parenthood, where she would make appointments to try to later prove that she went there, but like actually she didn't show up. But he would have known that there was no Planned Parenthood Los Angeles appointment there. Because it wouldn't have been reflected in the portal. But he's trying to say, like, it's the bar's fault. I can't remember what exactly was there. Well, you would have known around the time of the hearing.
Yeah. The problem is on June 10th when she says, I went to LA, and Tiandra's like, are you introducing this here at trial today?
Right.
That should have been like a big thing for him to try and figure out and fix, right? Or something.
Right.
Oh my gosh.
So here's kind of where he addresses that a little bit. Although respondent had checked Owens' Planned Parenthood portal and knew it did not have records reflecting that she attended an appointment or had an ultrasound performed at Mission Viejo, he never took any steps to correct her false deposition or June 10th hearing testimony that her ultrasound was performed in Mission Viejo or additionally in the case of the hearing, Los Angeles. And
that's
he's
a
like,
good point too.
He says, no, I repeatedly explained this to Jim Lee that her testimony on June 10th, where she said that she went to Los Angeles, was for the purpose of correcting her prior testimony. No.
What?
You had access to her portal. You had an obligation before that hearing to explain that she did not attend an appointment at Mission Viejo or get an ultrasound there. You had that obligation. And then to say that on the day of the hearing, her saying Los Angeles was correcting her prior deposition testimony, I don't fucking think so. That's not going to work.
Here's why I don't buy that, Lauren. When she talked about LA,
probably because it's a lie, but go on.
When she talked about LA, that was under cross-examination by Deandra. That was not under initial direct examination by Gingras. It wasn't Gingras saying, hey, Laura, you're on the stand now. You're the first witness of the day.
Yep.
Would you like to correct your previous testimony or your affidavits in any way before we get started here today? Did that happen? No, it did not. It was only under what I would call anecdotally hostile cross-examination.
Right, yeah.
I mean, it's not legally hostile, but anecdotally hostile cross-examination that she admitted that or came up with it on the spot or whatever she was doing, rationalizing.
Mm-hmm.
So this is totally broken here.
And if they were to correct that, if he knew she was going to correct that on the hearing date, if he knew she was going to testify that, as he should have, otherwise he's lying about that being a correction, then he would have had the ability to log back into that patient portal and see that there was no Los Angeles appointment even made.
Yeah.
So this is not going to work. Like, it's a lie. It's not true.
Yeah, you don't want your clients saying something brand new on the stand you've never heard before. Like, that can't be good.
No. And again, that's why I'm saying, like, I think this is probably before you popped into the stream, but I was like, a lot of these issues are like the answers that he has to choose from are you negligent or are you dumb? Like, it's one or the other. There's no good answer to a lot of these questions, but he's trying to like give like answers that just don't add up, and it's not going to work in front of a judge any better than it did for Laura. So,
or, you know, some sort of, he's trying to finesse the system or he's being antagonistic. He has some sort of, you know, he's trying to game the system. There's a third option, right? I guess there are other options maybe, but whatever the reason is, I think it's irrelevant because we've got a lot of responses here where it's just admit or the bar has a good case.
Okay, so these next 2 points, I'm just trying to not make sure I don't talk forever here because I have been. These next 2 points are basically saying he became aware that they sought copies of medical records because of her testimony from Mission Viejo and that there was nothing to basically return from Mission Viejo. And then upon learning that, he was on notice that he needed to be more diligent and closely scrutinize what she told him, because she had said that she got an ultrasound at Mission Viejo. And he's like, no, I didn't need to scrutinize that. I didn't need to question that. No, I just, whatever. Like, that's... You're not even putting up a defense there. He's just like, deny. No, I didn't need to. No. Okay. He's very passionate in his responses when he's blaming Gregg, Woodnick, or someone else. But when there's no excuse for his behavior, you can tell, because he's just like, nah. He doesn't even say it in all caps like he does in the other ones. Like, he's just like, yeah, I resign. This is my fate.
Because in this one, there's no Woodnick or Mata to attack. Right. So it doesn't need all caps or underlines or bold.
Yeah.
And, I think this is getting to maybe explaining why all these prior lawyers, right? Lexi Linval, Corey Keith, dipped out at some point.
Yeah.
Because they were probably doing their due diligence and didn't like the result they were getting from it.
I mean, they couldn't ethically proceed given what she was doing. And he has decided to kind of put his, head in the sand and be like, well, I don't know about that. That's not good enough.
It's a possibility.
Yeah. All right, let's see. Respondent was aware that Echard alleged in his motion to compel that he, Echard, or his counsel, received a confirmation from nearly all providers that she was never a patient of theirs, which we know to be true in regards to the obstetricians or the specialists, right, for pregnancy. And he says, I was aware of the allegation, but that's not consistent. And that's going to be a problem for him too, because they're going to be able to show those records, those attempts, and to be able to show that they said, no, there's no record of her here for XYZ person. It doesn't matter if the Barrow Institute has a fucking record of her, because that has nothing to do with her pregnancy. When it comes to the pregnancy, almost every provider she said she had seen, almost all of them, were like, no. Mission Viejo, Planned Parenthood, Dr. Higley, Dr. McCool. They did not have a record of her as an actual patient. She made appointments. She did not attend them. She did not attend those appointments. Therefore, she was not a patient. So,
I mean, there's nothing that confirms clinical pregnancy or paternity or miscarriage. She can go get a HCG blood draw. Yeah. Or she can tell the neurologist something, or a therapist.
That's how Bruce and I found out about our baby. So,
but I mean, those aren't fundamental to when you're trying to put the evidence on the table from a provider to Woodnick that says, yes, there is clinical pregnancy. We're going to get paternity data. Oh, did a miscarriage happen? Here's the clinical miscarriage report from an ER or whatever, OBGYN. We don't have any of that. We don't have anything we need. So I don't know. I think they're splitting hairs here.
I mean, the mom doc thing, I would think, is one example of one where she was actually a patient there, but there was no proof of pregnancy there. There was not even proof of a miscarriage. She just went there and was like, well, I miscarried. And then they wrote that down in their little notes like they're supposed to, because most patients who go to see these doctors are not lying. So doctors don't just automatically trigger an investigation into the patient's claims. So they wrote down there failed pregnancy or missed abortion or something like that. There's not actually any proof of a pregnancy or a missed abortion, which is another way of saying a miscarriage there. That's not an actual fact. It's just something that she reported to them. And the fact that she's reporting things to multiple providers and making appointments she doesn't attend that are not just not true, and she's not truthful about them, is enough to say I'm sorry, but that record doesn't mean anything to me, So, yeah, I mean, that's maybe beyond the scope of this bar complaint, but I just wanted to rant about that. So, all right. Anyways, the motion to compel placed respondent on notice he needed to be diligent. And again, we know how he feels about diligence. He doesn't need to do that. Respondent learned prior to the June 10th hearing that she had not gone to Planned Parenthood in Mission Viejo. He denies that, even though he looked at her portal and would have known that she did not attend that appointment.
That's weird.
Which is, again, why he doesn't offer any explanation here, but okay. Prior to the June 10th hearing, Owens told respondent she had made appointments with Planned Parenthood in Southern California on 2 consecutive weekends. So, sure, but she didn't attend them.
You know what I find funny, Lauren?
You would find the ultrasound in there, by the way. You could go in there and be like, there was an ultrasound done, and then a lot of times you click on an image that's uploaded. But go ahead.
That'd be nice. Yeah, we would like that. That's what I'm saying. It's ironic because in all these cases or throughout this Clayton case, Laura's been like, oh, I'll give you my patient portal logon, right? It's like a meme of
Mhm.
her telling people she'll give them the patient portal password. And
Yeah.
Gingras is the one guy who gets the password and goes and logs into it, and he doesn't remember any of it.
Yeah.
Like, it's kind of funny to me.
Yeah. There's just so much to unpack here. It's a lot. Okay. Owens admitted to respondents she had altered the sonogram prior to the date she hired him. She admitted to Mr. Woodnick during her deposition, that she had altered the sonogram, and that based on respondents' review of the deposition transcript, he learned of that admission. Okay. So did he just like not ask questions about that? I'm curious because I know they have her emails with him on at least some occasions, because her emails with him are how the statement about Dr. Medchill questioning her credibility came up. So I'm curious as to whether or not they have an email that shows she admitted to altering the sonogram. It's quite possible. I don't know. I'm just saying
maybe it just didn't come up in their conversations, Lauren. Maybe they were too
that goes
busy.
back to the lack of diligence.
Maybe they were too busy trying to come up with names for the twins or something. I don't know.
Oh, good Lord. Well, I mean, I know they named the feral cats Lauren and Megan, but I don't know about the twins. So let's see. Draft affidavit. Okay, so on April 15th, respondent sent a draft affidavit to Owens to review and sign, after which she informed him by email about some possible changes, including the following. This is what I'm saying. They have some of their emails, because she informed him by email about some possible changes, including maybe don't include the ultrasound since I tampered with the top. Wait a minute. So here Owens admitted that she altered a sonogram. Wait. Owens admitted to him that she'd altered a sonogram. And he's like, well, I only learned about that through the deposition. But down here in 137, they're saying he knew about this because she said in an email to him on April 15th, I tampered with it. So
maybe he didn't read this email. Maybe it got stuck in the spam folder, Lauren.
Well, he admitted to it right here. He admitted to it.
Oh, well, that's not good for him.
So here on 136, he's like, he says in response to Owens told him that she altered the sonogram, he's like, well, she sent it to Woodnick, and I learned about that through the deposition transcript. But then on 137, he admits that she actually emailed him about tampering with it.
Yeah. So they're both true. Two things can be true at once.
No,
Yeah.
Bruce.
How
No.
does this contradict?
Okay.
What's the problem?
Because if she emailed him saying she tampered with it, then she did, in fact, admit to him, not just through the deposition transcript, that she altered the sonogram.
Yeah. Well, he's just not saying anything about that. He's admitting that he read about it in the transcript.
No. Sorry, no. Okay.
I'm sure. Wait, when was this depo? Because I'm sure he read the
March
depo.
1st.
Okay. So he read the depo transcript before this email on April 15th.
Sure.
So he's technically correct.
They're asking though, at any point, there's no date here, admitted to David that she altered the sonogram. And here, in fact, we have an email that where she admitted to David that she tampered with the sonogram.
Yeah.
And he's saying here he only knew that because of the transcript.
No. He's saying that's when he learned about it for the first time. He's not saying anything about learning about it for the second time.
Can you tell me where in this statement here it says for the first time?
He learned of that admission. So once you learn it, you know it, and then you'll hear it again.
We've established that he doesn't do his due diligence. So how am I to know that he reviewed the deposition prior to April 15th?
Oh, well, he's responding and saying he did.
And also, whoa. His responses mean nothing. How am I to know that April 15th was the first time she admitted to tampering with the top?
I think what we've learned here, Lauren, is that Laura is trying to tell
guys, we're
her
about
attorney.
To
She's Laura is trying to tell her attorney all of the naughty things she's done. And he's like, yeah, she told me. but it's not a big deal. I don't know.
Anyways,
I think I would do a very bad job as this guy's attorney in this case.
I mean, you would have done a better job than this, though. Because all he had to do was in this is say admit or deny. He didn't have to do any of this shit.
Oh, that's true.
Okay. On April 16th, respondent discussed with Owens the draft affidavit he had sent her on April 15th. Okay, sure.
Oh, the affidavit. I like this one.
Later on April 16th, she executed the affidavit that he drafted and which was attached to the April 26th response to the amended motion for relief based on fraud. Okay, he admits that. Owens' affidavit included an image of the altered sonogram and stated in part, on July 2nd, while traveling in Southern California, I made an appointment with Planned Parenthood for the purpose of obtaining pills to medically terminate the pregnancy. My mother drove me to the Planned Parenthood location on July 2nd, but she did not come in with me. I took a photo of the sonogram screen with my phone, but I did not want Clayton to know where I had gone for the appointment, as if that fucking matters. To conceal that information, I modified the image to change the facility name from Planned Parenthood to SMIL, and I also changed the date from July 2nd to July 7th. A copy of the modified sonogram image is shown below, and we don't have that right here, but other than changing the top part of the image to alter the facility name and date, I did not change any other part of the image. That's going to be a problem here.
Ooh.
Because she did, in fact, alter more than the facility name and the date. Well,
Really?
we know that, but
We do?
Yeah, she changed the name of the patient. She put her name on it. So she changed the patient name.
This is from the investigator's report.
So what we're talking about here is in the affidavit he had her sign.
Yeah.
Right.
But the information that she changed, more of it would have come from the investigator's report because they probably found out where the original came from.
Oh, sure.
Because this is the ghost, right? The ghost one, the high contrast.
Honestly, dude, they all seem the same to me at this point.
Oh, boy.
I know there was no Fiverr logo on this one, if that helps.
Well, you know how clever it is to say she took a photo of it with her phone, because then it wouldn't be in, then that gives you the explanation as to why it's not in the patient portal.
But so she took an image of the monitor with the phone, right? But the doctor would still upload the image to the patient portal.
No, because she went anonymously.
Yeah, that's not a thing.
Or under a fake name or something. I don't know.
Yeah, that's not a thing. That's not a thing.
Yeah, the story doesn't. It's not a good story, Lauren. But I see where it's going.
Oh, this is so sad. Okay.
I know the train is going to crash. It's just I can admire the tracks while it's doing that.
The tracks are broken. Okay. Anyways. All right. Respondent subsequently learned that Owens had allegedly gone to Planned Parenthood in late June 2023, but took no steps to correct that false statement in her affidavit. Okay.
He's denying that.
Right. That's okay. I don't know what to say to that because he doesn't really say anything else. The sonogram that Owens claimed was from Planned Parenthood, shown above, includes her real name, even though that sonogram was not a sonogram that resulted from an ultrasound that had been performed on Owens. Okay, so it was not her sonogram, but she altered the name to show her real name. And he gets confused by this, so that's why I'm explaining. Owens stated in her affidavit that she had not changed anything other than the name of the facility and the date. So she did, in fact, change more than that. She changed her name. And then he says, respondent cannot understand what this allegation is claiming and therefore denies.
Oh, no. The ghost ultrasound is a big old fakey fake.
Yeah.
I'm pretty sure it's the ghost ultrasound because the sister ultrasound on the wooden table never made it into the court record.
Just the fact that we're having to argue with like not even argue, but having to explain that between the sister ultrasound and the ghosty ultrasound and the Fiverr ultrasound should tell this lawyer enough that he should have done a better job. Don't
forget the reality Steve ultrasound. There's 4. Don't forget. We can't leave Steve out of it.
Oh, I'm sorry, Steve. Exhausting. This is actually exhausting.
It is.
Okay. Owens told respondent she went to Planned Parenthood anonymously and then later using a fake name, said she went using a fake name. Okay, so this here, I think this is a little nitpicky. I think if you're saying that you went anonymously using a fake name, you could argue that using a fake name is being anonymous. However, they do require ID, so that neither one of those things is a possibility. That's stupid. But they're basically saying that she didn't tell the truth on two different occasions because she said these two different things. And in that situation, I actually think they can argue that that's the same.
Why is he saying this allegation misstates the facts?
I don't know. Misstate the facts or combine two different issues. So I guess there's an issue that she used a fake name and there's an issue that she was anonymous. Maybe, but that, like I said, I think those two things can be kind of combined. I think they can kind of mean each other. I think they're both false, but I think that you could argue that they're the same,
Well, if she said she went to Planned Parenthood anonymously, like in the deposition, and then on June 10th, she said she used a fake name.
You're right.
Then 145 would just be correct statements. So I don't know what his response is here. What's the problem?
Well... I don't know. I've been trying to figure that out for 3 hours almost. All right.
Yeah.
Based on the respondent's review of the transcript of the March 1st deposition, he knew that she either testified falsely by stating she went anonymously and subsequently changed the name of the facility and added her name to the sonogram, but did not change the date, or B, signed a false affidavit stating she altered only the facility name and date. Okay.
Fair.
I mean, he denies that. I don't know why. That's a pretty obvious fact, in my opinion. But respondent failed to take steps to address Owens' false testimony during her deposition or to address her false affidavit. So he would have to do what Corey did after the fact, which is to come in and be like, I now know, here's a notice of candor. I now know that I made this representation to the court and it was false. And he found out when he was, doing his investigation into all this, that what she said during her deposition or wrote on the affidavit would not have been true. He reasonably should have figured that out before the hearing, and he just denies this. So I don't really know. Again, he's trying to say on the day of trial that they corrected this or addressed this by making a different statement on the day of trial, but you are obligated before trial to disclose that she went to Los Angeles to get an ultrasound before the hearing so that they can obtain those records. You can't just do that. That's not allowed.
You don't just say whatever you want under oath and then go to a trial, and then if they ask you about it, you correct it.
That's not
just cross your fingers and hope they don't ask you about the things you said that were wrong before.
No, so court is not like Suits. It's not like TV. You don't surprise people on the day of trial the way that she did. You can't do that. So
the motion of candor from Corey Keith should have been a hint,
right? Exactly.
That he should take out the magnifying glass a little bit or something.
So here's one of the most insane things I've seen about this entire. Oh my God! Hang on, let me do this real quick. Pull this up so we can have the image, because the images.
Me, Lauren.
The images on this. You showed me this earlier. I think actually is what happened.
I want to be shocked again.
You want to be shocked again? Hang on.
Yeah.
I have to move back in my messages before.
What is he saying? Respondent failed to verify with Planned Parenthood whether it treats people anonymously or people using fake names.
Right.
Good question. Deny.
What page are we on here? I have to go to the same page on this
52.
one. Okay.
And affirmatively allege, due to medical privacy laws, it is not possible to conclusively verify whether Planned Parenthood has ever provided care to anyone anonymously.
Dr. Deans was an associate medical director of Planned Parenthood. Dr. Deans knows how Planned Parenthood operates.
We would hope, yes.
Right. So do a lot of just women in general. I mean, it's just not hard to determine. But doing your due diligence as an attorney requires more than reading one sentence of a Google AI summary after the fact. So, I mean, this is where he said he denies that he failed to verify that Planned Parenthood whether it treats people anonymously or use fake names. So I guess he he didn't think necessary to call and ask these questions. He didn't think necessary to visit their website. Here, in fact, is his due diligence. He says, deny and affirmatively allege due to medical privacy laws, it is not possible to conclusively verify whether Planned Parenthood has ever provided care to anyone anonymously. Okay, first of all, no, that's not how that works.
That's
You
not
can
the
call-
question.
You
Yeah.
can call and ask, will you treat people or provide ultrasounds to anonymous patients? And they would tell you, no, we require ID.
Yeah, you're not calling them up and asking, did Lauren get care anonymously? You're asking,
Yeah.
is it even possible? It's a process question, not a medical data question.
Right. And he says, and or whether Planned Parenthood has ever violated its own policies in this regard. Are you kidding?
What?
It's not possible to verify whether or not Planned Parenthood has ever violated its policy not to give anonymous patients ultrasounds.
What is happening? Is his argument that Planned Parenthood did something they weren't supposed to do?
Yes.
Well,
He's
that's,
saying, I
that's
can't
a pretty
verify.
extraordinary claim.
He's saying, I can't verify whether or not Planned Parenthood broke their own rules to give
Well-
Laura an anonymous ultrasound.
That's a bit of a bridge too far. I mean, we haven't even gotten there yet. We don't even know what their baseline policy is, let alone whether they've violated their policy.
Right.
So,
Okay. So
if you go investigate and you find out Planned Parenthood has a particular policy, and then you say, hey, my client, Laura, this is the Planned Parenthood policy, so I don't understand what you're telling me that you want to put in this affidavit or what your testimony is in this deposition. And she's like, well, they must have broken all their rules. Be like, well, we're going to need to see some evidence that they broke all these rules. Like, that's a very
person
audacious
rubbing together
claim.
2 brain cells or more would be able to tell you that, like, she's accused of lying. She admits she altered an ultrasound. And then you're like, well, maybe Planned Parenthood broke the rules. Oh, no.
Show me
Isn't
the
that what
Google.
happened?
Show me the Google page. I want.
Oh, yeah. Wait, let me get through this first. In addition, anecdotal evidence. This is the anecdotal evidence. We're going to get to the Google page. Appears to confirm that Planned Parenthood does provide both confidential and anonymous care. To the extent Dr. Deans testified on the contrary on this issue, respondent assumes the state bar is in the process of pursuing discipline against Mr. Woodnick for suborning perjury. So
No.
Dr. Deans, the former associate medical director for Planned Parenthood, perjured herself.
That's not
And
how
Mr.
this
Woodnick
works.
suborned it. Not because, why is that? Why is that?
Because of this
Because
Google search.
Google AI says, yes, you can receive confidential and in many cases anonymous care at Planned Parenthood. Okay. And what does it say beyond the red line, though? Where your information is protected by law. So they're talking about HIPAA and privacy. They're not talking about, we're just going to go give a patient an ultrasound and be like, well, here's Jane Doe, the 4000s. And then go, oh, that's not fucking, oh my God.
Here's my problem with this,
Idiot.
Lauren. If you look at this carefully, so I have 2 problems. Number 1, if you look at what he put in here, he says, can you go to Planned Parenthood anonymously? That is the wrong question.
Can
The
you receive
correct-
services?
The correct question to ask is, can you get an ultrasound at Planned Parenthood anonymously? And if he had typed that question, the AI overview would say, no, you cannot. You have to give them ID first, which is exactly what Dr. Dean said. Now, my second problem, if you scroll back up, I don't know if you can scroll back up.
Hold on.
Where's his little statement up here? This is just nitpicking. If you scroll up, he says, anecdotal evidence appears to confirm. Now, we don't need to be Jack Fox to understand that this is a statement that has no weight behind it, right? Like, anecdotal evidence. First of all, anecdotal evidence is not good evidence. Appears, that's not a very strong word, to confirm. Appears to confirm. This is such, like, he's winging it. He's winging it. He did the wrong search in Google. And I did it earlier today. I said, I put in his sentence, can you go to Planned Parenthood anonymously? And I got basically his AI overview. And then I said, can you go get an ultrasound at Planned Parenthood anonymously? And I got a very different answer. It was basically, no, you can't. So this is crazy.
Can I get an ultrasound at Planned Parenthood anonymously? Let me zoom in on this a little bit, guys.
What did you get?
Yes, you can receive a confidential, low cost or free ultrasound at Planned Parenthood without parental notification, as they adhere to strict patient confidentiality. Well, you cannot be entirely anonymous. You must provide personal information for medical records. Your
There it
records are
is.
private and will not be shared without your permission.
There it is. So you have to give them the ID.
Way to go, buddy. Good one, Dave. I mean, I don't even know what else to say that. That's ridiculous. Absolutely no due diligence at all. My God. Excuse me, Google AI is not a permissible witness. Liz says there is no foundation for this information that a court would accept. Written affidavits are not accepted by courts without a live witness. Yeah, so Google AI gets shit wrong all the time. I would know because I was looking for spoilers on TV shows, and I was deeply disappointed to find out that what Google AI was telling me was not true. Okay, I just watched Lost for the first time, and Google
boy.
AI really told me some shit that just messed me up. Okay, so I know that Google AI is not accurate.
Have you watched all the seasons though? It might still
I did.
be
I
right.
finished the whole. I finished the whole thing. Yeah.
Oh, you finished the whole thing.
I did. Yeah. Yeah.
Oh. But do you know about the orangutan and what's the girl's name that goes off looking for her dad? Anyway,
No, I don't know about that.
I digress.
Yeah. Well, we'll get into that some other time. Anyways, so yeah, this like saying that Dr. Dean's perjured herself and that Mr. Woodnick suborned perjury. How is this defending himself against this bar complaint? He looks like an absolute. I'm really trying to tone down the rhetoric against this man, like I keep advising him to do against the judge. You know what I mean? Like tone it down. But like this is absolutely nonsense that you would use a Google AI summary here that doesn't even say what you think it says, and then accuse a reputable doctor who was an associate medical director for Planned Parenthood of perjury. Like, what are you doing?
Dr. Dean should file a bar complaint for the response to the bar complaint that's a result of her original bar complaint.
Jesus.
We're going to have bar complaint inception here.
If you want the secret ending stuff for Lost, I have the $500 DVD set.
Oh, secret ending stuff.
Yeah, send it to my P.O. box, man. All right, anyways. Let's move on from that before I like burst a vein.
Oh boy.
All right.
That
on April,
that was a lot.
Oh yeah, it was. On April 18th, respondent sent an email to Owens stating that he had told Echard's counsel that she went to Planned Parenthood on July 2nd, but that he had located an email message from Dr. Zeman dated June 28th stating she had gone to Planned Parenthood the previous weekend. So why didn't you provide Clayton's in response to their medical request, why didn't you respond Clayton's counsel with that disclosure?
What?
So she told them she went to Planned Parenthood on July 2nd, but he located an email from her to Dr. Zeman where
Who's he?
One Dr. Zeman, I can't remember which.
No, the he. Who located this email?
David.
Gingras?
David, yeah.
Ooh.
So David saw an email from her to Dr. Zeman stating that Laura went to Planned Parenthood the previous weekend. So why didn't David correct the record?
Ooh.
Why didn't David correct the record?
Oh, this is very weird.
Oh, it's not weird. It's just it's all making sense now. Okay. Anyways, June 3rd, Corey Keith filed a notice of candor. Right. We don't need to go over the candor stuff because we all know about that. Attorney Keith summarized Owens' deposition testimony in that notice of candor, right? He included evidence establishing that Owens had testified falsely before Cynthia Galketsis several months earlier in the injunction against harassment proceeding. He says respondent is not aware of the evidence referred to in this paragraph.
He's not?
It was his job to know that. It is
Why
now
not?
his job to know that. Like, why does he? Oh my God.
He never read the motion of candor?
Fuck if I know. Apparently not. I mean, it's before his time. Right? Well, it's not before his time, but he just ignores stuff that would not have worked in his favor in his case. And rather than dip out like every other reputable attorney who did that, he was just like, you know what? It'll be fine. No one's going
He's
to care.
not
about
aware
that.
of it?
I can get away with it. It's fine. Yeah. I'll just pretend I didn't see it, you know?
I feel like if we asked him like what the temperature was outside at his house, he just would be like, I'm not aware of the weather.
It really, like, he can make his case or try to make his case for that, but like it appears to people who have been following this case, who have seen everything, it appears that he is being intentionally obtuse. That's how it comes across. Let's put it
Oh
that way.
boy.
And again, maybe he has some evidence that he wants to present in his hearing, but he appears to be acting in a way that is intentionally obtuse to me. I think, no, this is ridiculous. Respondent failed to take steps to address her false statement to Judge Galketsis. Okay, he says, respondent again reminds the bar and the PDJ that he did not represent Ms. Owens on November 2nd, 2023, and was not present at that hearing. Respondent was not retained to represent her until March 25th. You still had to familiarize yourself with that file and then make sure that you didn't present any of the false information from the Galketsis hearing again in court. My God. Attorney Keith also noted in a notice of candor that Owens testified before Judge Galketsis that she had seen by Dr. Higley last Friday, but stated during her March 1st deposition that she had an appointment with Dr. Higley but did not attend. Okay, we admit that. At some point in time, Owens admitted to respondent that she incorrectly testified before Galketsis when she said she had actually only made an appointment and didn't actually go see him. Mm-hmm. Although respondent David was aware of the content of the notice of candor, he failed to diligently investigate and research Owens' statements to him, which he presented to the court. So again, they're saying like he was aware that she had made false representations in an adjacent case to this one involving some of the same issues with the same people. And he failed to diligently investigate whether or not she was telling the truth in their case. So
he doesn't know the evidence, but they just sort of laid it out here. Does he want more?
Apparently, I don't know.
I mean, it's not all you can eat buffet at the Perjury Cafe. I don't. Oh boy.
Prior to June 10th, he reviewed transcripts and video of prior hearings, Owens and Echard's deposition transcripts, the file maintained by Owens' second attorney, I think, was that Corey Keith, I think, including documents he prepared and filed, the report prepared by Echard's expert witness, disclosures made by Echard's counsel, the medical records provided by Owens, and possibly other records and information related to issues in the paternity case and related cases. Admit. Okay. Based on the information he acquired, he was aware that Owens testified falsely before Judge Galketsis and made false statements during her deposition, altered a sonogram, which he offered into evidence during the June 10th hearing, signed an affidavit that included false information, which was filed with the court.
Oh, also bad. Oh, this one's the bad one.
Admit that at some point, respondent learned that months before he agreed to represent her, again, this doesn't matter, Ms. Owens made inaccurate statements regarding seeing Dr. Higley versus making an appointment at a hearing which respondent did not attend and which were ultimately not relevant to any issue in the paternity action. It was a hearing in the case, right? No, we're talking about a different one. Okay.
This is the order of protection. But I mean, your client is under oath.
Okay, so this was brought up in the deposition, right? It was brought up in the deposition, but it happened in a hearing that was not in this case. It was in a related case that they mention here, and he admits related cases that other records and information that were something that he had to review, right? Okay, admit at some point that she made that admission about not seeing Dr. Higley, right? A hearing which respondent did not attend, which were ultimately not relevant to any issue in the paternity action. Respondent further admits that at some point he learned that Ms. Owens, let me X that out, made admissions in her deposition to the effect that she had changed the facility name on the Planned Parenthood sonogram, which Ms. Owens admitted in her deposition before respondent represented her. David denies ever learning prior to the conclusion of the paternity cases that Ms. Owens had lied during... that Ms. Owens had lied during her deposition or that she signed an affidavit that contained false information. How?
Oh boy.
How? If he accessed her Planned Parenthood portal, how?
Also, another reason to go rewatch the February status conference hearing, they took judicial notice.
Right, exactly.
Of the injunction against harassment order that Clayton got against Laura.
Yeah.
And that's where all this happened. So it's relevant.
Mm-hmm. Oh, respondent knew that Owens had not been truthful about facts material to the case, but not withdraw from the case or take sufficient steps to address her false statements and the altered sonogram. He denies that, says he affirmatively alleges sonograms are not relevant, nor are they material to any issue the court may consider in a statutory paternity establishment case.
Oh,
Okay,
boy.
this went a little beyond that, though. He was asking for, attorney's fees and costs related to her fraudulent claims. Like, she brought forth claims of pregnancy knowing that she was not pregnant.
Well, no, also, if your argument is that Clayton got you pregnant, but then you miscarried, your best path at proving this claim is to get a consistent OBGYN and go get ultrasounds.
Right.
Because at least you can prove pregnancy. And if you prove pregnancy and then say, oh, I had a miscarriage and that's why Ravgen can't work, you actually have an argument at that point, right?
Mm-hmm.
But she fails to make the pregnancy claim stick because of all this, arts and crafts and yada, yada.
Yeah.
So it is relevant because it could have made your case stronger.
Right. Right, but we're not gonna address that. It's immaterial,
Oh boy.
Cassie says whether she filed the paternity case in good faith goes directly to whether she was even pregnant. All right. This is okay. We're almost done here. We're almost done, guys. Okay. Paternity establishment in Arizona family courts are not courts of general jurisdiction. So this argument that he's making, this doesn't belong in an answer like this. Like, this is not the purpose of, you're affirming or denying these things. You're not making it like an argument. So I don't know why he's arguing so much here. This kind of stuff honestly seems irrelevant to me because you're no longer arguing with the court as to whether or not a sonogram is relevant. You're arguing with the bar as to whether or not you knowingly presented false information. So shut the fuck up. This is, oh my God.
That's a good point. If you go back to the actual charge wording, he should be trying to refute these claims.
Mm-hmm.
So here's what he's doing. They're saying respondent knew that Owens had not been truthful about facts material to the case. So he's going to argue, well, those facts aren't material. So that's what
they were relevant because they were arguing over whether or not she should have to pay him attorney's fees based on bringing fraudulent claims. So those things were in fact material.
Yeah, correct. Because if she had proven she was pregnant, but then couldn't prove that Clayton was the dad through Ravgen because of a miscarriage, and if she proved a miscarriage, then I don't think Clayton would have been awarded fees. I think the judge would have just said, "Look, we can't do a ruling of non-paternity or paternity. So you just both go your own ways, pay your own fees." Right?
Yeah.
That's probably what would have happened.
Right.
But because of all this nonsense that happened along the way, she threw her credibility under the bus and couldn't prove any of her baseline claims.
Yeah.
And now has 14 felony counts from a grand jury.
Yeah, that's all.
Oh boy.
Yeah. Okay, so we're not gonna read this entire rehashing of the case because none of this fucking matters in regards to his bar complaint. I'm not gonna do all that.
Yeah, I think we get the idea. He's just trying to argue that these things aren't material.
And he really thinks that somehow the judgment in that case is going to get overturned based on his bar hearing, as if Judge Mata saying Planned Parenthood is closed on Sundays is somehow material to whether or not Laura Owens faked a fucking pregnancy.
I don't.
Okay.
That one I don't understand. So
yeah, I don't know. So maybe that's why he's rehashing the case. I don't know. During the hearing, let's see, he admits that we don't need to fuck with that. Owens testified on direct examination. She went to Planned Parenthood under a fake name, which was contrary to her deposition testimony that she went anonymously. Again, I think this is a little bit nitpicking over words. I guess you could argue that, but I think it's a little nitpicky over words compared to the rest of the complaint. I just don't think that's very strong. So. I mean, how did
she go under a fake name? Does she have a fake ID?
Oh no, it's a lie. The whole thing's a lie.
Well,
But yeah.
well, what I'm saying is, if she went on her fake name, how'd she do that? Does she have a fake ID?
I
And
don't
if
know,
she
they
does
should
have a
ask
fake
her that.
ID, where is it? And can she
Yeah.
provide it to the MCAO?
Right.
Because it will prove her claim that she went under a fake name. Of course,
That'd
they
be
may
nice.
charge her for having a fake ID, which
Maybe she gets
probably
all of
shouldn't do.
her income for the businesses that she owns to her fake name. I don't know.
Oh boy.
Maybe that's where all that went. Okay, let's see. The deposition and trial testimony is a matter of record. We don't need to worry about that. Okay, let's just go back.
Ooh, a lot of admitting.
Yeah,
I like it.
it's good that he's actually just using one-word answers for a little bit. Owens further testified during cross-exam that she had changed the date on the sonogram from July 2nd to 7th, and the July 2nd date was the correct date. That testimony conflicted with her deposition testimony when she stated she had not changed the date on the Planned Parenthood sonogram, and her testimony during direct exam that the ultrasound was conducted in late June 2023.
June, July. Oh boy.
Okay. He responds to that. The deposition and trial testimony of Miss Owens is a matter of record. As for whether the
What?
trial testimony was contrary to her deposition testimony, this is a matter of argument, which respondent cannot admit or deny without reviewing both transcripts in full. So do that.
What, doesn't he have the transcripts? What's he
Yes,
waiting for?
He responded to this in 2 days. He could have
Is he-
taken more time
wait.
and looked over those things and given an answer.
Why can't he? This doesn't make any sense. Without
No, it
reviewing,
doesn't.
why doesn't he just review the transcripts?
Well, I think we know.
Control F. I don't know.
Oh, God.
What?
I'm sure one of us could have provided him with a copy if he really had a problem. He knows where to go to find it. It's not like he doesn't stalk the fucking JFC subreddit. You know what I mean?
Lauren, I can't come into work today because it would require me to get in my car and drive there.
God. I actually
Like
would
what?
accept
So
that
do it.
excuse.
Like what?
Jesus. All right.
Oh no. He's kind of
we're
proving the bar's point that he didn't do
Oh,
due
yeah.
diligence by not even doing due diligence in his response.
yeah.
Oh
Okay.
no.
Here's another really dumb one. Okay, there was testimony presented during the June 10th hearing that Planned Parenthood requires patients to provide identification and does not allow anyone to obtain services anonymously, which Dr. Deans did say that, okay? And he says, admit that Dr. Deans offered this in testimony, but deny that Dr. Deans established that she had personal knowledge on this issue. So you deny that Dr. Deans, the former associate medical director of Planned Parenthood, established that she had personal knowledge
I
on
think
whether or not Planned Parenthood requires ID.
here's where Dr. Deans failed. Dr. Deans needed to go get a trench coat and one of those big fedora hats
Oh,
and pretend to be someone else and go to Planned Parenthood anonymously and see if they kick her out or not. And if
I don't
she had
think
done
need a
that,
trench coat
we
for
would
that. Maybe just like
that would be some personal knowledge.
you don't even need a trench coat. You just like maybe do a little of that fake sideburns action and mustache. You know what I mean?
I don't know if Dr. Deans would look good in sideburns and a mustache.
They treat ugly people at Planned Parenthood, Bruce.
I mean, maybe it'd be a good look. I don't know.
I'm so tired. All right, anyway, we're almost done. We're almost done. Okay.
Oh no.
Respondent did not take any steps during direct or redirect examination to address Owens' false or inconsistent testimony. See about the ultrasound dates and all that. He says, as has been explained to bar counsel repeatedly, respondent understood that when Miss Owens changed her testimony at trial, that change was made to correct previous errors in her deposition testimony.
No, I
We
don't
all
buy
know
that.
that's not acceptable.
I don't buy that.
A lawyer knows that is not acceptable. Like
I
you
don't
have
buy
to like seriously dumb yourself down to think that that's okay. All right. So he denies these. Of course, he denies the violations based on all this stuff, which I guess he showed if he wants to defend himself. So what else is he going to say at that point? All right. He denies, of course, that the appeal was frivolous, which I think they're going to have a hard time with that one. Because it's hard to like prove that somebody did something frivolously. I feel like you could just argue that he did a bad job, which is like not the same. Which is that part seems certainly true, but that's not frivolous. You know what I mean? It's just stupid.
Yeah.
Okay. He does some dispositive stuff, like defenses, dispositive issues, where he can kind of put out affirmative defenses here. There's, of course, probably the anti-slap thing. I can't remember what he puts here. The court lacks subject matter as to the alleged misconduct. These allegations accuse respondent of acting unprofessionally when he sent an email that contained assholes and fucking assholes. Again, the problem is that he introduced himself as the attorney for Laura Owens and related the respondent Clayton Echard in that issue. And in his professional capacity, reached out to Reddit to communicate over a legal issue. And that's when he used those words. It's not that he used those words. He can use those words, just not in his maybe professional capacity as an attorney. I don't know. That's up for debate. Apparently, because he's going to try to defend himself there. It's going to say he says he's not engaged in the practice of law because he's acting for himself in legal matters. And the problem with that is he didn't introduce himself as acting in his own capacity as his own lawyer. He introduced himself as the attorney for Laura Owens.
Yeah. And he spends a bunch of time saying, what was it? Like, I have to go get on Twitter and make YouTube videos and argue with people in public because I don't think Laura's story is getting told the right way or something. Like he argues, I had to go do PR for her.
He's also said that he obtains her permission before saying anything publicly about her situation. Or he said multiple times, I'm waiting for approval. I'm waiting for this or that. He is acting then as her attorney, not as a rando. So, a lot of what he said has been in that capacity. And
so he's mixing up all this PR and the legal work. Yep. And it's just... Especially when he... and also, I don't buy the argument that Laura never got her side of the story out there because we've read a whole dozens of Medium blogs and all the court filings that they submitted.
Well, this started with her story in the tabloids as well. So and then he on his law firm blog posted a long article about her struggles and her words, including her suicidal meanderings on his blog as her attorney, his law firm blog. His law firm website. It's like some of the stuff that he says, you can't say it's just free speech as an individual outside of the professional context. If you're doing it on your law firm blog and representing yourself as the attorney for the client whose words you are presenting to the public, it's just not going to work like that.
You've suddenly commingled your PR and your legal work, which is not advisable. Yeah. But even if you ignore his PR, I think his claim that her story wasn't being told properly is incorrect because we saw all her blogs and all her filings. So if he'd never said anything except written filings to the docket, we'd understand her story. Yeah.
Well, we have also, I wanted to point out here, he uses this argument as well when it comes to his response to my bar complaint and stuff about what he said about me in the court in California. He uses this excuse that he was acting on his own behalf. So he was enforcing his own legal rights. Therefore, he's not engaging in the practice of law. And so he can abuse the courts however he wants and get away with it. I'm like, that's not something that you should be admitting. First of all, that's embarrassing. Second, everybody can then see what you're doing whenever you file something yourself in a court case that you're not a party to or an attorney for one of the parties. You're abusing the court. It's pretty obvious. So that frustrated me. But of course, that's the excuse he's going to try to use because he abuses his legal knowledge and his license and his professional experience to attack people in court where it's not appropriate because he can be like, well, look, I'm not acting as anyone's attorney, so I can say whatever I want. Fuck you. Seriously. All right. While respondent admits to the Arizona Supreme Court has jurisdiction to regulate the practice of law, the Supreme Court and this court do not have plenary, how do you say that? Plenary jurisdiction over those who are not engaged in the practice of law simply because they happen to be lawyers. Yeah, the thing is, he represented himself as an attorney at the time. So he uses the anti-slap law, of course. I'm sure Mark will represent him there, and Mark is, to my knowledge, Mark is a pretty good attorney. We'll see how that works out. Maybe it'll work out for him. Maybe it won't. Unfortunately, that's not going to work out for him in response to all of the charges because a lot of it's because of his lack of due diligence, which has nothing to do with free speech.
Fair.
The state bar's allegations in this matter violate respondents' constitutional rights to due process and equal protection. Among other things, they've acted unlawfully by seeking to punish him for violating rules which are unconstitutionally vague, both on their face and as applied. I don't know about that. I'm not going to say anything about that because I don't know. Be honest. I have no idea. Seeking to punish for violating rules in a manner which violates his rights to free speech. We kind of just addressed that. Violating court orders, which were unconstitutionally vague. No, I'm sorry, no. And or which conflicted with other orders, such that they failed to provide respondent with notice regarding the scope of prohibited conduct. I don't buy that.
Oh boy.
Selectively seeking discipline against respondent in a manner which arbitrarily violates the state bar's own policies. Again, I don't know what he's getting at there, so I'm not going to really comment on that.
That's the, if you're coming at me for X, why aren't you coming at Woodnick for X or Y? Or that's what that is.
If that's what that is, then that's pathetic. I mean, okay.
Yeah.
Arbitrarily ignoring misconduct by others involved in the same yeah, okay. So that's not going to work out. That's not going to work out. Adopting arbitrary policies and applying them in an arbitrary and unfair manner. Okay, then. Retaliating against respondent for engaging in protected speech, which is kind of what we addressed earlier. Engaging in prejudicial delay. The delay thing, I honestly don't know. Like, obviously they had a lot of complaints to investigate. It sounds like they took their time doing this. And it included the appeals as well, which went into sometime into last spring, did it? I don't know. I don't know how long that went into, but yeah. I mean, a lot of this stuff was ongoing. So, I mean, I don't really know what else you can say about that.
I mean, I feel like the bar here may have information from the MCAO.
Could be, yeah.
Oh boy.
Sorry. There you are. Finally, that's over. Sorry. I couldn't click out of that fast enough. I was like, I'm so fucking tired.
And yet he gets to delay his DUI hearing all he wants, I guess.
Yeah.
And we don't know why. Which doesn't make sense to me.
I don't know about that. It seems like he doesn't want to talk about that as much as he wants to talk about about the other stuff.
Yeah, I mean, it's important, but, I don't know. I think we're learning. For me, the bankruptcy is number one. We learn the most interesting things there in these bankruptcy cases. And then maybe this one actually is very interesting as well.
Yeah.
To read the bar complaints.
Yep. All right, guys. I gotta pee soon because it's time to go to bed. It's almost 12:30 and I gotta sleep. So, all right, thanks everyone. I appreciate that. Did you get that crap off the docket in CA? The judge never ruled on that, but honestly, I got to say my piece about it, so that's fine. I would love it if she did, but I'm not gonna push it. You know what I mean? I feel like that's inappropriate. So, all right, thanks guys. Appreciate this, and I will see you all. If not tomorrow, then the next day. We'll see. Not about this, but about something else because I need a break from this. I've talked about it for 3 hours, so. I'll commit a crime or something. We can talk about that.
Very good. Well, hopefully Omar will cover this tomorrow or this week or something.
Oh, I'm sending you guys over to my friend Cassidy, by the way. Tell her Lauren sent you and tell her hi. Thank you very much.
Yay.
Bye.